Good afternoon, folks. 6 hours of argument time is requested. I imagine nobody wants to be here for 6 hours, so I would ask that you seek the time that you need to convince us of your most important points. You do not have to educate us about your appeals. I assure you that we are a hot bench and are familiar with the briefs, the record, and the arguments. And just one bit of housekeeping, the red light comes on, please finish up your thought. Obviously, if a justice is asking you a question, you may answer that question. The red light is a reminder for you folks, but of course, the judges here have the prerogative of talking over the red light, which we will do from time to time. People versus DeLone. Counsel? 3 minutes? Okay, so 5, 1, and 3. Wesco Insurance versus Nunez Dental.
5 and 3, please. Respond in 5 minutes.
5, 3, and 5. J. Children, submitted. Alfonso versus True Car Leasing.
Appellate Dry Ice Corporation, 4 and 2. Responding 4 as well, please.
4, 2, and 4. Holder versus Jacob.
Appellant, Your Honor, 8 and 2 for rebuttal, please.
Responder.
6 and 2 and 6. Federal Insurance versus BD Hotels.
Appellant, Your Honor, I did 4 and 2. Probably less than that.
Well, just why don't you tell me what you want?
4 and 2.
4 minutes, you got it.
Responded 3.
4, 2, and 3. Marlboro versus New York City Transit Authority. 7 and 3, you got it.
Your Honor, the plaintiff respondent requests 6 minutes, please.
Third-party defendant, respondent, Emra, 3 minutes, please.
7, 3, 6, 3. Debray versus Roy Land Investments.
Your Honor, appellant requests 7 and 3.
Respondent, please, 5 minutes.
6, 2, and 5. People versus Torres.
Appellant requests 6 and 2. Respondent requests 5 minutes.
6, 2, and 5. Marjon International versus Lillian August Design.
Appellant requests 7 and 3.
Respondent requests
5, 2, and 5. Sue versus Carlton Commodities.
Appellant requests 6 plus 2, Your Honor. Respondent requests 6, Your Honor.
6, 2, and 6. Consorca Management versus Mouchoir.
Appellant requests 5 and 2.
Respondent requests 3.
5, 2, and 3. Brainick International.
Appellant requests 5 and 1.
You know, this was non-enumerated. There had been, were there requests for argument in this case? Okay, are you both here? Okay, how much do you want, counsel?
5 and 1.
I'll give you 4 and 2, 4 and 1, and how much do you want? Okay, 4. First case up, People versus De Leon.
Good afternoon, Your Honors. In this case, the court erred when it refused to grant an adjournment for the hearing and trial for a short period of time, given the information that it had that Mr. DeLone was using drugs again, but in constant communication with his attorney and expressing his desire to be present. And
Doesn't that run counter? If he wanted to be present, he could have,
well,
right? Because counsel spoke to him during that weekend, right?
That's correct.
And I would only assume that counsel told him that there was a warrant out for his arrest. And yet, here comes the date and defendant's not there.
A warrant hadn't been issued yet, however.
Well, he failed to appear previously, and the court was anxiously awaiting his appearance.
That's correct. But I do want the court to keep in mind that this entire inquiry took place over the course of 4 days, which included a weekend. There was very little time for his attorney to be able to reach out to him, to get him back on track.
But it happened, right? Whether there's very little time or not, the fact is that during the course of that weekend, defense counsel spoke with the defendant, and the defendant yet still failed to appear in court the next day.
That's correct. But at the same time, the court, before holding the Parker hearing and during the course of that inquiry, had expressed concern about whether a medical emergency might involve a problem with voluntariness. Because, as the court is aware, Parker is about more than sufficiency of warning, right? And the court should have done a factual finding about voluntariness here. It failed to do that, even though it was concerned about this issue. And the defense counsel kept saying, with just a short adjournment, Your Honor, I believe I could get him here. He's using drugs again. He's not able to function and come to court and assist with his defense. With a little bit of time, I could do that. And the court did not continue into that inquiry, even though there was concern about it, and focused more on the sufficiency of the warning.
Did the defendant ever voluntarily appear?
The defendant was brought in July for sentencing.
And how much after the trial, the hearing and trial, was that?
So that was about 6 weeks later. But it's important to keep in mind, too, though, that at that point, he had given up. He knew that it was over. He knew that it had been done in his absence. The fact that he was on the phone with his attorney every day during that period of time when they were discussing this and saying that he wanted to be there, but he simply could not function and get there, should have triggered the courts making a factual finding about whether it might make sense to adjourn the case for a short time. Cases that I cited in my brief that the court is aware of say that the court shouldn't move forward unless there's a prejudice, unless it would be futile to try and get someone in, and if the public interest outweighs the defendant's right to be present at trial.
Here, when we talk about the futility of getting the defendant in, the fact is that he knew that he failed to appear, that the court wanted to move forward, yet he didn't come in. And in terms of the public policy, wasn't it the people's position that a witness of theirs may become absent in the near future?
So the people did tell the court that their witness had told them that he wanted to leave New York, but that was it. It was a vague reference to this. There was no plan. The court wasn't made aware
It wasn't
of.
like they had tickets in hand and were going to...
Exactly. The witness said, I don't want to be in New York anymore. So adjourning the case for a week or two really wouldn't have prejudiced their case. They had a very simple case. The hearing and trial took 2 days. This case was called for hearing and trial on a Thursday. The court put it over to Friday for briefing and then went forward with the hearing and trial on Monday. And they happened...
Why wasn't that sufficient time? Just I think your argument would hold more water, at least for me, if there hadn't been even an adjournment over the weekend. There was an adjournment. The client doesn't show. Why can't the court at that point believe that, based on the Parker warning, that the defendant had validly, at this point, waived his right to be there based on what occurred with the adjournment?
So you're right that there was a weekend, but the point here is that the right to be present at your own trial and to participate in your defense is an important one. And 1 weekend, in order to get him there...
What's enough? 1 month, 2 months, 3 months?
A week, 2 weeks. The lawyer was asking for 1 to 2 weeks. That's all. It wasn't a big ask. And she
And what
felt...
would have changed? What would have changed from a weekend as opposed to a week that the defendant would have been convinced that it was in his best interest to be present?
Well, we'll never know the answer to that. I think if the court had given them the opportunity to try that, and they came back and said he still isn't here, then maybe that would have made sense.
I think my colleague's question is important in that, did you tell the court what the court should expect? Because from the court's perspective, what the court is hearing, defendant spoke with the attorney, must know that he's wanted, right? He's failed to appear and is still not here. So did you tell the court, if you give us a week, this is what we anticipate? Because just saying that he relapsed, that's unfortunate. But what does that mean in terms of him coming to court?
I think the fact that he was in communication with his lawyer so consistently, that he was wearing a suit and coming to court that day but wasn't able to make it, tells us something about his desire to be present and assist in his own defense. I think it's worth giving a simple case with one civilian witness and no indication that the people would have been prejudiced with the short delay. It's worth finding out if the lawyer could have done it.
Thank you, counsel.
Thank you.
You may proceed.
May it please the court, I'm Philip Tisney for the respondent. The defendant in this case was told that his case would proceed without him if he didn't show up to court. He didn't show up to court, not once, not twice, 3 times. And it's not like he didn't know that he was supposed to show up to court because he was talking to his attorney the entire time.
Well, how do you respond to your adversary's point that a week or 2 adjournment would have given counsel an opportunity, maybe a defendant an opportunity to be present, as opposed to just commencing trial after the weekend?
So I think the trial court exercised its discretion reasonably in this case because the 2 adjournments that it had already given the defendant didn't work. And as we know, in retrospect, this defendant didn't turn up for 6 weeks or 8 weeks. He could have turned up to court voluntarily 2 weeks after his conviction in absentia, and he didn't. He was returned involuntarily in sometime in late July.
Counsel, was there prejudice to the people in giving defendant that extra week?
There was the concern that the witness would move out of state. There was a concern as well that he would stop participating. This witness had showed up, I think, 4 or 5 times at appearances, prior appearances, thinking that the case was going to go forward.
In terms of your due diligence, if I understand this correctly, there were officers who were not sent to his last known address. Isn't that like 101?
You know, the officers weren't sent to the address. Somebody called the last known address. They talked to, I think, his aunt. I think the answer to that is, could they have done more? Perhaps. But what they did was sufficient to try to make sure that they could find this defendant. And the bottom line is that this defendant didn't want to be found. He knew he had to come into court, and he evaded the court's jurisdiction on multiple occasions. It's not just the 2 adjournments that he was given before trial. The trial took 2 days. He didn't show up once during the trial.
Then what are we to make of the communications he was having with his trial counsel? This isn't a situation where the defendant simply absconds, but there's some communication here on the morning of the trial.
Just more to the point that his refusal to come to court is a voluntary and knowing waiver of his right to be present. He knew he was supposed to be present. He
Because
knew what would happen.
What we know from that is that the defendant knew that this proceeding was about to start, and there's no specific or articulated specific reason why he's not showing up.
Precisely. And just to be very clear, this case, the defendant was present in court when the case was sent out for hearing and trial the next day. And when it was sent out, the defendant said, I'm not going to show up anymore. He was in contact with his attorney that morning and said, oh, yeah, no, I'm coming in. But then he didn't come in. The court said, you know what, let's put it over till the next day and we'll see what happens. Didn't come in that day. Court said, you know what, I think this is enough. We're going to go ahead without him on Monday morning and we'll see what happens. We'll give him the weekend to show up. But if he doesn't show up on Monday, we're going forward without him. He didn't show up on Monday, even though he was talking to his attorney the entire weekend. That's the testimony from his defense counsel. And they went ahead with the trial. They did it for 2 days, and then he didn't show up for another 6 or 8 weeks. Under the circumstances, the trial court was more than reasonable in affording this defendant every opportunity to come to court, and the defendant just didn't.
Thank you, counsel.
Thank you.
Just very briefly, I just want to address a couple of things. The people contend that the witness came to court a number of times. I'm not sure that's entirely accurate. I'm not casting aspersions about the suggestion, but
What we do know at this point is that the defendant knew that this was about to take place. He's been put on specific notice of it, and we're not giving a specific reason why it's impossible for him to show up, other than his lawyer saying, well, he's back on drugs.
well, that is a specific reason. But The
But
court may
there are
not like
people-
the
There are
reason.
people who are on drugs who would be able to show up.
Well, I would hope that the court wouldn't go forward if someone were using drugs and at counsel table trying to participate in a trial. I think they would probably adjourn it for that reason, most likely. But I do just want to point out that the people answered ready
Point
4 or
is
5
that he's
times.
unable. There's nothing establishing that he's unable to show up.
Well, no, we have circumstantial evidence that he's in touch with his counsel, that he's on his way to court, that his
And
family
that's
says
just as
that he wants to
consistent
come.
with, and that's just as consistent with him having made a volitional decision not to come.
You can interpret it that way if you like, but also most people who abscond and don't come to court don't talk to their lawyer over the course of the weekend and every day, aren't in touch with them. Usually they just
Back
go.
on drugs, would a week would a week make him come in?
Well, again, I don't think we know the answer to that. I think it would have been worth trying.
Exactly. What basis did the court have to grant that, except for the lawyer saying, I spoke to my client, he
Yes.
knows what's happening, but he may be back on drugs?
Well, no, she said more than that. She said that she was back on drugs, but I think that the court has discretion, and the discretion, the analysis should be the importance of the right to be present versus prejudice to the case. And that's why I wanted to address I don't think the witness came to court a bunch of times. I think they answered ready several times. I'm not sure the witness was there for that. But what I'm saying is that it wouldn't have prejudiced this case. Adjourning this for a week or two, the case would have gone on if he hadn't come in. And this right is of such import that it was worth giving that little bit of time.
Thank you, counsel.
Thank you.
Wesco Insurance versus Nunez.
Good afternoon. May it please the court. John Golashevsky on behalf of the appellant. This court should reverse the summary judgment order because it ignored black-letter New York law concerning both the prior acts and the criminal acts exclusion and effectively rewrote coverage law of New York. As to the prior acts exclusion, in applying this exclusion, the trial court impermissibly went outside the four corners of the complaint and relied on an
So
interrogatory
in
response.
deciding, first of all, whether Wesco had to provide a defense for Nunes, we look at the complaint and the underlying action, do we not?
That's correct, Your Honor.
Based on that based on the complaint and the underlying action, what is the justification for not having provided a defense for Nunes?
That's a question for my adversary. I don't believe that there is any justification for not providing a defense to Nunez at all, Your Honor. Not only are we looking at the four corners of the complaint, we're also looking at the third-party complaint that Nunez filed. That is, when Wesco is making a coverage determination, it is not only looking at the complaint, it's also looking at extrinsic facts. This is the Fitzpatrick case in the Court of Appeals, which is from 1991, which says that we look to the totality, maybe not the totality of the circumstances, but certainly third-party complaints. Nunez alleged that her image was used without consent. Even if we agree with Wesco that there's an allegation of criminal conduct, and we don't, and it's laid out in our briefing, I don't need to get into it here, but even if we agree that there's an allegation of criminal conduct, what Nunez then says is that, no, I didn't use her image without consent. We had consent, and they alleged it in the third-party complaint. So when Wesco goes to make a coverage determination, they have to look at the complaint, and then they have to look at the third-party complaint, and then they have to determine whether or not there is a reasonable possibility of coverage. And from our position, Your Honor, there is absolutely no question that there is a reasonable possibility of coverage. Davalos says her image was used without consent. Nunez says, no, it wasn't. They sue a third party on this ground. A duty to defend is triggered. The prior acts exclusion was used by the trial court, however, because of an interrogatory response filed in this lawsuit. This is 3-4 years after Wesco made its duty to defend analysis. And again, if we go back to Fitzpatrick, what Fitzpatrick says is whether there exists extrinsic facts suggesting the claim may ultimately prove meritless or outside the policy. Even then, the insurer cannot avoid its commitment to provide a defense. Even if that interrogatory response was issued in the underlying Nunez matter, and it wasn't, it wouldn't matter as to a duty to defend analysis. The trial court cites no authority, Wesco cites no authority, and that issue requires reversal of the order. When we're looking at the criminal acts exclusion, as I mentioned, there's two important points. One is that we're looking at the complaint and the third-party complaint, the totality of the circumstances there. But at the same time, the Wesco exclusion only excludes coverage for criminal acts committed by the insured, which they defined as the insured is Nunez or its officers or directors. And again, even if criminal conduct was alleged, it was never found by the trial court. Wesco concedes this at page 18 of their opposition. Here's what they say.
Dr. Nunez was never convicted of any crime, correct?
That's exactly right. Of course not. Quote, if Nunez used Davalos' image in advertising without her consent, as alleged, then under Civil Rights Law 50, it committed a crime. If that happened, there was never any finding that that happened. So when we're talking about the duty to defend, which is all we're addressing here on the appeal, the duty to defend was triggered because, as Wesco concedes, there was never any finding. We talked about the use of extrinsic evidence. They brought something up in their opposition, which I just want to address, which is this idea that there was only potential coverage under subsection E of personal and advertising injury, which is the right of privacy. We believe there is certainly coverage there, but it's not accurate. There's also coverage under subsection F, which provides for an advertising idea. And we lay this out in our papers, and I'll hold the rest of my time. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Max Gershwire for the respondents. The entire problem with the argument that counsel just made is that when you analyze whether there's a duty to defend, you must assume, and this is from the Court of Appeals, you must assume that what is alleged actually happened. This makes sense. The question is, if the insured is found liable.
Before we get there, aren't you bound by the four corners of the complaint in terms of determining whether or not a duty to defend arises out of that document?
Typically, yes, not always.
What cases do you say support you that you can go beyond the four corners of the complaint?
There's the third department case that we cite for the idea that if the extrinsic evidence does not intersect with the liability in the underlying case, and it's to clarify an ambiguity, it can be used. So, and I also want to emphasize.
Okay, so what is the positive proof? I think that case used the term positive proof. What is the positive proof here to clarify an ambiguous pleading?
Okay, let me be clear. This issue deals only with one out of the three coverage defenses that we're talking about. For the prior, right? So for the prior publication exclusion, that's the only one we're talking about in terms of extrinsic evidence.
That's right.
Is the fact that the complaint does not specify when the advertisements were made. So we have to look, in order to establish whether or not that exclusion applies, you have to look at extrinsic evidence. We did. We got
And so what do you say is so powerful, as in the third department case, that it would be sufficient to find for you on your behalf?
Because the insured, right?
Go ahead. In the interrogatory response?
Yes, the interrogatory response.
Was the interrogatory response that clear?
I believe it was. I think the question was, when did you start using Ms. Davalos' image for your advertising? And it was years before the first policy incepted.
But don't the photographs have to be substantially similar, for example? Have you established that? What do we know about the photographs? We don't know anything.
All that has to connect all of the advertisements is that the same wrong, it gives rise to the same wrong. The wrong alleged in the complaint exclusively is that Nunez never obtained.
So it's your position if the photograph is completely different.
Doesn't matter.
It doesn't matter.
Doesn't matter. Doesn't matter.
Okay.
But how can an admission by the insured in the coverage action be used to clarify a purported ambiguity in the tort victim's action?
It's because the tort victim, when the tort victim has a judgment and seeks to recover that judgment against the insurer, they stand in the shoes of the insured. So the fact, it's essentially an admission by the claimant herself that this is what happened. But I'd like, again, because there are three different coverage defenses, and the other two have nothing to do with extrinsic
So
evidence.
let's go to civil rights law, the
Sure.
misdemeanor.
Right. The factual predicate for all the claims in the underlying action, each cause of action the same, that Nunez used Davalos' image without consent. That is exactly the description of a crime.
So essentially what you're saying, it's strict liability, right?
Strict liability.
Well, any case that you cite to says that this statute is a strict liability offense?
There's neither, I found case law neither pro or con. It just didn't address it.
So why, I'm sorry, go ahead.
But if you look at the text of the statute, it's quite clear. And in fact,
Anything in the legislative intent that would support that it was supposed to be strict
I
liability?
believe so, Your Honor, because there is a provision in Civil Rights Section 51 that says if the insured does this knowingly, they are then subject to exemplary damages. The necessary implication is even if it's not done knowingly, it's an offense. It just doesn't subject the insured or the perpetrator to exemplary damages. So I think that is a necessary inference that's drawn.
Are there other forms of mens rea besides knowingly?
Well, that's the only, again, if you read the text of the, I'm going by the text of the statute, there's nothing that talks about any sort of mens rea. So
So when that happens, a mens rea is inferred, isn't it? Isn't that the general practice? Then when it's silent or not crystal clear on the mens rea, that it doesn't just become strict liability.
again, I think because of the exemplary damages for the knowing use, that implies that there is no
And that
mens
goes
rea
back
required.
to my colleague's question that there are other mens rea.
Right. Well, again, I think if the plain language of the statute indicates that there's no mens rea. But quickly, I'd like to go to the third coverage defense. Even though, as I'm sure the court is aware, even though the lower court did not either reject or accept the third exclusion, this court has every right to rely on a ground not relied upon by the lower court to affirm. In fact, the exclusion, the intellectual property exclusion, the third defense that's discussed, is the exclusion that courts around the country have used to find that there's no coverage for.
But is the claim limited to intellectual property rights? Aren't there also claims with right of privacy, publication, and all that? Wouldn't that be still viable?
The right of privacy cause of action is based on a violation of Davalos's right of publicity. In other words, every claim is based on the idea that Davalos's right of publicity was violated. So,
Not right of privacy.
well, the right of publicity is a kind of right of privacy. In other words,
So isn't that beyond intellectual property, I guess, is the question I'm trying to get
right, and I would say no, because the right of publicity, and I've cited many cases, is recognized as a intellectual property right. The particular kind of right of privacy violation here is a violation of publicity rights. So this is not a generic.
So you're saying it's a subset of it, and therefore it's
Exactly,
Got
and
it.
it's the particular subset that's alleged here. Every cause of action is based on that same factual predicate. None would exist, therefore, but for the fact that Nunez violated Davalos's publicity rights. So every cause of action is based on that. Also like to point out that the only cause of action that counsel for Davalos says is outside the scope of this intellectual property right is trademark. But trademark is also excluded in the very same exclusion for all intellectual property rights. Trademark infringement is part of that same exclusion.
Thank you, counsel.
I don't think we need to get into the IP exclusion at all because the lower court did not opine on it. But the one case they cite,
Well, but you should address it.
and we put this in the footnote, the one case they cite, Posada versus Aspen Specialty, they said somehow is in favor of application of the IP exclusion. The court there held the exact opposite in a very similar underlying case based on misappropriation. We put that in one of our footnotes.
Going back to actually sort of the more interesting argument, and that's with respect to prior publication.
Sure.
Your adversary argues that admission in the interrogatory is sufficient, doesn't matter what the photograph is, they don't have to be substantially similar. How do you respond to that?
I respond that there is not a case in America that has ever held that. Every single case that we are looking at, whether it's the Street Surfer case that they cite, whether it's the Taco Bell case from the Seventh Circuit, every single case looks at the pre-coverage publications and the post-coverage publications and makes a comparison. The trial court was in zero position in order to make that comparison here. This court, on de novo
There's
review.
material attached to the complaint from 2018, right?
I'm sorry, Your Honor?
There was material attached to the complaint from 2018.
Correct? And before?
What do we know about the relationship between that and the 2009 photo?
We know nothing. We don't even know that a 2009 photo or photos exist. Nobody's ever seen them. This was their summary judgment motion. The onus was on them to put before the court evidence of the substantial similarity between the pre-coverage publications and the post-coverage publications.
In other words,
and
it's
they didn't
based
do it.
essentially on the admission itself without looking at the photograph.
Which is, again, issued 3 years after the duty to defend, and which says, the interrogatory says images. Which images were they? Your Honor hit the nail on the head that could there be different images, different content. This is what Taco Bell and that whole line of cases turns on, including the Street Surfer case, which they said does not turn on that. You look at the Ninth Circuit there, and they're specifically making those comparisons. We don't need to get into the weeds about mens rea, in my opinion. But if we were, nobody is talking about a strict liability crime here. What they are talking about is an accusation by Davalos that Nunez used her image without consent. Davalos saying, we didn't do anything, we had consent. And under their interpretation, the Nunez officers are still somehow guilty of a crime. That this is not a strict liability crime. This is someone who did nothing at all, who has no omission, in the case of a bail jumping, for instance, that there is no omission, there is no overt act, and somehow under their interpretation of Section 50, which has never, ever been used to prosecute as a criminal act, under their interpretation, the defendant, Davalos Nunez, is somehow guilty of a crime. It does not make a lot of sense, Your Honor. Finally, there is an interest of justice standards in the Slako case where the court, and we lay it out from the Court of Appeals, in which they say in sum or substance, there could be a hypothetical situation in which an exclusion should not be applied. And again, we lay this out for a few pages. I won't belabor the point. But the Slako, the Court of Appeals opinion in Slako also, we believe, supports coverage. Thank you for your time.
Thank you, counsel. Thank you both. Alfonso versus Trukar.
Good afternoon, Your Honors. May it please the Court. Matthew Corcoran for the Appellant Dry Ice Corporation. Just out of clarity, there are two appeals here. My co-appellant, Trukar, has decided to submit their brief. With respect to my appellant, Dry Ice, the issues are much more limited. There are only two causes of action pled against my client, both grounded in the penal law, which is our allegation. Plaintiff does not have a private right of action to bring. There are only two ways they can raise this.
Well, let's assume we agree with you that there's no private right of action. But can the plaintiff affirmatively raise the allegations in order to avoid the effect of the Graves Amendment?
Well, Your Honor, I think in order to answer that, the Graves Amendment has built into it a means by which the plaintiff cannot assert a criminal cause of action. You can bypass the Graves Amendment with respect to either criminal activity or negligence. And again, the Graves Amendment not being explicitly asserted against me, I don't have any arguments addressing that in my brief,
Right,
but
you're
it does
dealing
have
with
that
sixth cause of action, aren't you?
It does have that safeguard that the legislature built into it, that you can also assert negligence in order to bypass the Graves Amendment, and that's one of the considerations.
Well, negligence or criminal wrongdoing, correct? That's the exception in the Graves Amendment?
And negligence, yes, it can be one or the other. But again,
Or both.
It can be both if both exist. But again, in analyzing whether or not he has the private right of action to bring it, one step in the analysis is whether or not the legislator has created other avenues that he can assert. And he's asserting negligence in this case against Trukar and against the other defendants, which would be sufficient for a private citizen in order to bypass the Graves Amendment. And again, one of the other elements in order to have a private right of action is whether or not the plaintiff is a member of a particular class for which the statute was enacted. That's the three-part analysis for an implied private right of action, which we don't have here. Reckless endangerment in the second degree was not enacted for the benefit of any particular group of people, certainly not truck drivers, with all due respect. Now, the other cause of action against my client is a declaratory judgment action in which he's seeking to invalidate a lease agreement between my client, who was his employer, and True Car Leasing Company, who owned the vehicle that was leased to my client that plaintiff was driving at the time. Now, again, the basis of his argument here is grounded in penal law, so I'd argue this cause of action must fail for the same reasons the direct cause of action in the penal law must fail. But additionally, plaintiff has not shown that they've suffered either direct harm as a result of this contract or that they are an intended third-party beneficiary, which are the only two ways a non-party to a contract can insert themselves into a declaratory judgment action here. The contract itself was not illegal. It was not designed to disadvantage the plaintiff in any way. And the best that he can show is that he's an implied third-party beneficiary here. There's now express language in the contract that is meant to benefit him. And without that, he cannot insert himself in a declaratory judgment action. Unless there are any other questions, I will reserve my time.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Joshua Block on behalf of the respondent. There's a couple of things I'd like to first address as to the non-appearing appellant. Firstly, if you look at the brief, they said they did not move under 3211 subsection A1, so they just are not relying apparently on documentary evidence. The other thing
Can
I
you
would like,
address the sixth cause of action?
which
Can you assert a private right of action? Is that what you're seeking to do?
no, we do not have any specific cause of action seeking to recover damages for
So
a
what
violation.
precisely are you seeking to do in the sixth cause of action?
It's a part of the larger.
Well, why is it different than the negligence cause of action?
I'm sorry, are you talking about the penal law?
Yeah.
Okay. So the reason it is there is because it reflects upon the Graves Amendment. It's obviously an exception to the Graves
You
Amendment.
can get out of the Graves Amendment with negligence. You're also trying to get out of it by alleging a penal law violation. So what is it that you are trying to do with that sixth cause of action? You're saying you have a right to do something with it beyond just an assertion
It's
of
essentially
negligence.
a clarifying is what it is.
What's that?
It clarifies. So if you look at it, it says very specifically, we are not seeking money damages under this. I don't have the exact
Well,
quote.
what is it that you would propose to do with this violation of the penal law if you were at trial on the case? How would you be presenting that?
We would be presenting it in the context of the Graves Amendment, and we'd be presenting it in the context of whether or not the contract, whether or not it can be enforceable or whether or not it's voidable.
So essentially, then you're pleading an exception
Correct.
to Graves. It's not that you're seeking affirmative relief.
100%.
Just
Your Honor.
trying to sort of maybe even prophylactically plead the exception to preserve any right you're going to need to deal with the Graves Amendment.
Yes, and that is it, and that is
But did I hear you to say that you also want to use the penal law somehow to void the lease?
yes. So you can't.
What's the
have,
basis for that?
So you can't have leases that are against that are illegal. And if you look into the complaint, the way that it's pled is the intent of it is illegal, and the intent of it is to is to get around liability. And
But you have the exception, right? If you're able to establish the exception at trial based on the facts as you're alleging them to be, and if you survive summary judgment, wouldn't that be sufficient to get around the Graves Amendment? Why would you need the lease then?
well, Your Honor, as you know, when you plead something, you plead it as fully as possible. And so that is what we have done. We obviously believe the Graves Amendment does not protect, and the reason why is the penal
Can
law.
you address the seventh cause of action, and that's your assertion that the plaintiff is a third-party beneficiary of this lease?
Yes. So the pleadings show that the plaintiff is not simply an identifiable member of the protected class. He is the protected class in this case, because what the lease does is it leases out a vehicle, which he then uses. And this is on page 213 of the record, is the specific section of the complaint. And it's fully addressed in our papers, the reason why. And Basically what it is the subject lease was entered into for the benefit of the plaintiff with respect to maintenance of repair of this subject motor vehicle. The subject lease agreement was intended to benefit the plaintiff herein with respect to maintenance and repair of the subject motor vehicle. The maintenance and repair provisions of the subject lease agreement were intended to confer a sufficiently immediate benefit upon the plaintiff herein. The promisee under the subject lease agreement intended to benefit the plaintiff herein with respect to the promised performance concerning the maintenance and repair of the subject motor vehicle. Those are allegations directly contained in the complaint, Your Honor.
Thank you, counsel.
Thank you, Your Honors.
2 minutes, counsel.
Your Honors, just very briefly, if you look at the 6 cause of action contained in the complaint, it's incongruous with what counsel represents in their brief. They are seeking monetary damages. They're seeking punitive damages. They're seeking costs. That's the language of their complaint, just to clear that up.
So, sir, if we were to agree with you that the 6th and 7th causes of action should be dismissed as to dry ice, would you agree that the plaintiff is still free to pursue allegations necessary to invoke an exception to the Graves Amendment?
Absolutely. He is in his other causes of action. There are negligence allegations against True Car Leasing and against the other defendants. And again, my client...
How about a reckless endangerment theory?
Well, again, Your Honor, we kind of go back to whether or not he has the basis to allege reckless endangerment. He can allege a civil cause of action of negligence, recklessness. That's all contained.
What's criminal wrongdoing? How is... It's not for you to establish plaintiff's case at trial, but how would plaintiff go about establishing criminal wrongdoing as an exception to the Graves Amendment?
I would defer to plaintiff's counsel to answer that question. Your Honor, quite frankly, I don't know that.
Fair enough.
And just another issue, when you asked about third-party beneficiaries, respectfully, I think counsel is confusing the standards between a private right of action, which is what they need to show that he is a member of protected class to do, versus third-party beneficiary, which means he needs to explicitly be someone who the contract is meant to benefit. Incidental beneficiaries do not apply. And the couple of cases that they do cite in their respondent's brief on that point deal more with Espinal exceptions, where a non-party is trying to insert themselves into a contract saying that you agreed to a duty, I was harmed by that duty that I relied on you to perform, so I should be able to assert negligence against you. They don't actually have cases wherein a declaratory judgment action is being asserted to invalidate a contract. And unless the court has any other questions, I'll rest on my papers.
Thank you, counsel. Thank you
Thank you.
both. Holder versus Jacob.
Good afternoon, Your Honors. Karen Lilling on behalf of defendants' appellants. This is exactly the type of case that falls squarely within the ambit of the first version of New York's COVID immunity statute. It applies to all patient care, regardless of whether or not the patient is being diagnosed with or being treated for COVID. If the legislature meant only COVID patients, they would have either repealed the first version or they would have made the second version retroactive, which they did not do.
Counsel,
Yes, Your Honor.
you're coming up on a 3211A7 motion, right?
Yes, Your Honor.
Okay. And so it's failure to state a cause of action. What is the deficiency in plaintiff's complaint?
Yes, Your Honor. Well, what I would urge, Your Honor, is that it's not that it's a 3211A7 motion, stressing that plaintiff doesn't have a cause of action. So when the movement, such as the defendants, provide extrinsic evidence in support of the motion, then the court does not have to assume the truthfulness of the allegations in the complaint. Instead, the criteria is whether the...
It sounds to me, counsel, respectfully, but there's a perfectly valid failure to timely diagnose departure asserted here. The question is what you're saying. You're moving essentially on a pre-answer motion to dismiss.
Yes.
On an affirmative defense that you haven't even pled.
Well,
that's basically, I don't see how you do that.
Okay, let's try it this way, Your Honor. In terms of the statute, there's no requirement in the statute. There's no analysis of departure or proximate cause with respect to the COVID immunity statute. If departure, and I'm not saying there is a departure, but if departure defeats the statute, then there would be no purpose for the statute in the first instance, and that's why there's an exception for willful conduct.
Wouldn't you have to raise this in the statute as an affirmative defense and then maybe move for summary judgment after there's been discovery, and we can then determine maybe what precisely was occurring during the pandemic at the hospital, whether or not the statute applies?
I would urge this court that the evidence, the affidavits provided on the motion to dismiss conclusively establish that the care and treatment was impacted by the pandemic.
How? He falls out of a bed. You have a question?
I have the same question.
Okay, so
He falls out of bed, the nurse comes, if I recall correctly, pretty soon thereafter, a doctor comes with the resident. He is displaying certain things. They presumably think it's related to colitis and not any neurological deficits. What was it the hospital couldn't do at that first initial time when the doctor and the resident came to the plaintiff's room?
Well, let's look at that care in this hospital. On that day,
Just answer my question. What more could be done? How was the care given at that minute deficient or was impacted by COVID, for example?
The way that it was impacted by COVID to begin with was that there was no bed alarm on the bed because of shortage of supply chain issues.
It's not the fall that's at issue. It's the missed symptoms.
So the missed symptoms at issue, you have doctors and nurses who were they were neurologists. They were not gastroenterologists.
But the claim is, it's a neurological claim that's being made. If there were a gastro claim, I could understand that argument. And also, just a little more, 5 hours later, then allegedly appropriate treatment is given. Why couldn't that treatment have been done 5 hours before? And again, how is that related to the pandemic?
Your Honor, those doctors and nurses had a full floor of COVID patients, if I may just answer the question.
Absolutely.
Okay, they had a full floor of COVID patients. Not only were they responding to codes and trying to save lives, they were focused on a condition that they knew nothing about. They knew nothing about COVID. They knew nothing about oxygen
This case is not about COVID.
That's correct. They knew nothing about gastrointestinal issues. So those doctors were focused on other areas of complaint for this patient. And if it was missed, and if there's an alleged departure, there was no willful or wanton conduct. And so this first iteration of the statute is designed to, when on the motion to dismiss, we provided 3 affidavits of people who were there at the time, which conclusively established that the care that was being rendered was impacted by the pandemic.
So
Not that there was
then-
no
So
departure.
essentially then, this is a quasi-summary judgment motion where the plaintiff doesn't get an opportunity to depose the affiants.
Well, this is not, it's a motion to dismiss.
But if it was a motion to dismiss, we'd be talking about the sufficiency of the plaintiff's pleading. What we're talking about is there is a defense, a very potent defense, that is dependent on certain evidence.
I would urge this court to look at Guggenheimer, the Court of Appeals case from 1977, 43 NY 2D 268. Once the movement provides extrinsic evidence like we did, it's not whether the plaintiff states a cause of action, it's whether the plaintiff has a cause of
So
action.
how about we have a slip and fall case, and the defendant moves on 3211A7 and puts in the affidavit of the property owner and says, I didn't create this condition and I have no notice. Why don't we just grant a motion like that?
But here, the evidence, if I may, conclusively establishes, and you can follow the precedent of not only the second department and the third department, but just today, a decision was handed down by this court, which, Your Honors, I have provided to my adversary and to you in Hansen. All of these cases, Martinez, Mirror, Whitehead, Hansen, they were all decided in the context of a 3211 motion, not a 3212 motion. What I am, and I recognize my light is on, Your Honor, but if I may, the serious...
Okay, I was on the Hansen panel, and quite frankly, the factual predicate of that case and this case are about as opposite as you can get.
Your Honor, I recognize my light is on. Any further discovery that the plaintiff has is in an effort to show that there was no impact on the care that was rendered at the time. But in this case, there's a wealth of evidence to show that the care and treatment was impacted. And I know that your honors have my brief, and it was laid out in the brief, but that floor that the patient was on, even though it was a neurology floor, it was converted to a COVID floor. Of course, the care and treatment was impacted. That hospital was 80% full, and almost 80% of those patients had COVID.
So why shouldn't
1,100, of
plaintiff-
course, the care and treatment.
Counsel,
Yes, Your
why
Honor.
shouldn't, and those are perfectly valid arguments, but why shouldn't plaintiff have the opportunity to test the validity of those arguments through a process we call discovery?
Because when, I understand your question, Your Honor, but in this case, after the defendant submitted those affidavits demonstrating that the care and treatment was impacted conclusively, the plaintiff had an opportunity to put in an affidavit. And yes, they did. And that affidavit only speaks of departure as if it were 2019. It does not take into account anything that was happening at that hospital. It does not take into account that the doctors had no knowledge of the condition they thought they were treating.
Counsel, I'm going to have to cut you off now. I've given you a lot of leeway over the red light, but hold your fire.
Yes, Your
I'll give
Honor.
you an extra minute on reply, okay?
Thank you, Your Honor.
Okay.
Good afternoon, Your Honors. May it please the Court, Richard Steigman from Garrett Coniston for the plaintiff respondent. As the Court has already noted, on this 3211 motion, for this Court to have reversed the motion court's denial of the motion, the defendant would have had to establish conclusively that the acts or omissions complained of in this medical malpractice case were for the treatment of the plaintiff himself, right from the statute, were affected by COVID and their response to it. So not
Actually,
only...
the people who treat the plaintiff initially, neurology resident Gross, is that they may have converted the floor to COVID treatment, but that physician is a neurology doctor.
He's a neurology doctor, and our entire claim is with respect to failing to diagnose and treat a hemorrhagic stroke, which is exactly what neurologists do. Justice Friedman, if I were here on a case where Terrence Holder came to the emergency room and he had COVID, and we said, you know, they didn't diagnose this correctly, they didn't act in accordance with standards of accepted practice, I'd have a loser. I'd have a loser based upon this statute, because clearly it would be impacted by the response to COVID. As Justice Singh suggested, if in fact this is a case about a failure to diagnose a bowel perforation, and the neurologists say, you know, I did the best I could, but what do you want from me? I did a residency in neurology, and now I'm reading textbooks to try to figure out how patients get treated with bowel perforations. That's encompassed, I'll tell you now, that's encompassed by this limited immunity.
So what is, sir, what is the deficiency then in there showing that the detailed affidavit that the entire hospital was affected by our response to pandemic, up to and including this particular floor? And we also were dealing with this situation, obviously, right in the infancy of the pandemic, not at some point a little more attenuated, but within the first couple weeks of the declared emergency in New York State. So what was the deficiency or deficiencies in there showing?
Because 3082B specifically requires, and in the same paragraph, that the act or omission occurs in the course of or arranging for providing healthcare services, and the treatment, in that paragraph talking about the act and omission, the treatment of the individual is impacted by the healthcare facility.
But that's what the affidavits have done. Why is it that sufficient?
I would suggest to you they do not. They talk very generally about, as the court has recognized, the fact that they've rearranged people on different floors. The brief argues that people were upset and concerned about COVID and giving it to their loved ones.
Is it your position that they had to explain how COVID-19 impacted the treatment of Holder?
The treatment for this patient, absolutely. And that word treatment is in the same paragraph referring to the acts and omissions. The legislature could have put it in a different paragraph. It's specifically defining and limiting the acts or omissions. It would be foolhardy to suggest that in April of 2020, life wasn't impacted by COVID. But to suggest that their affidavit is established, or even to go further, established conclusively to the point that plaintiff has no right to discovery, to suggest that would mean that the legislature really was giving an absolute free pass for negligent conduct as long as your hospital was treating COVID, no matter what you did, no matter how unrelated it was to COVID, end of story. And I submit to this court they would not have included that limitation in 3082B.
Sir, so how do you respond to your friend's point that at that point where we made a 3211A7 motion supported by evidence under Guggenheimer and Ravello, you now had an obligation to come back with something other than attorney argument to counter this point?
So two things. The context of this, by the way, it was not, they made a motion to dismiss, but they didn't do it pre-answer. They put an answer in. In your record, there are numerous emails going back and forth. When can we depose the doctors? Let's go, let's go. Yeah, we're working on it. I'm starting a trial. And then all of a sudden, they make this motion to dismiss. We asked the court to allow us to complete discovery before deciding the motion. The court, hybrid, the court allowed discovery to go forward, but also allowed the motion to go forward. So what did we do? At the time the decision was made, on the papers, we initially submitted the deposition of the nurse. Nurse Jacob concedes in her testimony that it was her obligation, having nothing to do with COVID, if she's aware a patient falls, to tell a neurology resident. The neurology residents, now, there are other depositions we submitted to the court, and it was not referenced in the decision. But for the purposes of 3211, if there's any possibility that what I'm about to tell you about the testimony, which we've already taken, is true, then the motion has to be denied. And this court should assume that these neurology residents said this had nothing to do with COVID. If the nurse had told me that this patient fell, I would have ordered a CAT scan. As Justice Singh pointed out, 6 hours later, when this poor young man is screaming in pain and another resident finds him, she says, we got to get this guy a CAT scan. Despite whatever's going on at Montefiore and COVID at that time, 24 minutes. 24 minutes from the time of the note to the CT, 90 minutes from the CT to neurosurgery for this patient in the OR.
Point that COVID had no impact on that treatment.
Had no, when their definition of impact from the dictionary is strongly or directly affected by something, especially in a negative way.
Thank you, counsel.
Can I say one more thing, Your Honor? We also submitted a tape. It's on 7424. If the court hasn't heard it, I strongly urge you to listen to it. It answers all of these questions, and it answers Judge Higgitt's question with regard to what we submitted. At 6 o'clock in the morning, Mr. Holder left a voicemail for his mother. His speech is slurred. He's plaintively
Counsel,
screaming.
we're aware of it, I assure you.
Thank you, Your Honor.
You're welcome.
Your Honors, on this particular day where Mr. Holder was, the floor was at almost 100% capacity, and 60% of those patients had COVID, and 5 were on a ventilator. The idea that Mr. Holder's care was not impacted by the pandemic, in my estimation, respectfully, it defies logic. That unit was not designed.
I'm sorry. The issue I'm having with that argument is that 6 hours later, it's determined that the plaintiff should be sent for a scan.
Yes, Your Honor.
Scan occurs 20, 30 minutes. That doesn't sound like COVID has any impact on what occurred at that time.
It does, Your Honor.
No, I'm just talking about that 30-minute time when he went to the scan. Correct?
Let me say it this way. This immunity statute, when I say departure is not part of the calculus, it's not that the defendant has to show that the alleged departure, I want to try it this way.
A departure doesn't overcome immunity.
a departure doesn't overcome immunity, we wouldn't need the immunity statute otherwise, because there's a willful exception. Proximate cause is not part of the calculus.
But
because
at the end,
yes, Your
what you
Honor.
have here is that someone, it's true that terrible conditions there because of COVID, and the hospital is really stressed out. But what happens is that someone comes in with a neurological condition, he's seen by people who have neurological training, and they fail to recognize his condition.
But that gentleman at 25 years old, firstly, they didn't know that he struck his head. And if you recall, the governor suspended documentation and recording during the period of the pandemic. Particularly, this was at the height of the pandemic. This is when the refrigerator trucks were outside. This is when there was no vaccine. This is when people were trying to protect not only themselves, and it took 15 minutes to change PPE from one patient to the next. So in
If he
terms
had
of
come in
time,
complaining not of gastro symptoms, but that he had a headache, would it change anything?
no, there is no question that this gentleman had neurological symptoms that were allegedly, and again, I'm not conceding departure, missed. But that's the purpose of this statute, this broadly interpreted immunity that should be satisfied.
So the way you interpret the statute is that any departure that happened during COVID, immunity.
Well, unless
Is that,
there
is
was
that a yes
willful.
or a no? Take aside, carve out the intentional.
Well, if I carve out the intention, then the
The
answer would.
intentional.
If I carve out the intentional, then the answer would be yes, but the answer is no, because there's a category under which liability should be permitted, and it was when it's willful or intentional, and there's a reason for that. It's because during the pandemic, even though you'd say, well, these guys are neurologists, shouldn't they be able to?
So it's enough to say it happened during the thick of the pandemic. There is no requirement that you show how the pandemic affected the care of this patient.
No, there is, and I think we've done that, and I think we've done that through the affidavits of Dr. Shamamian, Dr. Bahu, the nurse, and I believe that there was one other doctor, and forgive me, in the thick of it, I'm forgetting his name, to demonstrate that these neurologists were distracted by trying to not only save the lives of the people around them, but also to treat him for an unexpected, acute ulcerative colitis condition. That's what they were focused on. So this delay, and they should have, and they could have, it's because the pandemic, the impact of the pandemic, it impacted his care. And I know my
Counsel, finish up. Counsel,
but
finish up.
I'm gonna end with this. Mr. Holder received care in unprecedented circumstances prior to the vaccine and when people risk their lives. And as one doctor explained to me, the difference between a soldier going to war and a healthcare provider going to the hospital during the beginning of the pandemic is that the soldier didn't take their family with them. To affirm the motion court would be to eviscerate the purpose of the immunity statute and send the wrong message to the doctors and nurses who risk their lives, all in a heroic effort to save.
I just want to be clear that, at least speaking for myself, and I imagine members of the panel, the health community of New York, frankly, were the heroes. So we all recognize their sacrifices.
Yes, Your Honor,
Thank you.
I'm just very passionate about this case, and I appreciate the court's time.
Federal insurance?
May it please the court, your honors. John Ellison from Reed Smith on behalf of the appellant BD Hotels. I think I'm going to help you catch up on some of the time here a little bit. Just a couple of comments and I'll make them as brief as possible. If the court is not aware, the Consolidated Restaurant Operations case has been argued in the Court of Appeals and is under submission for decision. I think counsel and I both agree that this case is largely controlled by the outcome of that decision. So we would ask, and I will even agree here on the record, that if that case is affirmed based on the decision that was out of this court, then our case is over, and we concede that. The only other point I was going to offer, if your honors will indulge me briefly, and I'll not even use my 4 minutes. The one thing in the CRO decision that I'd like to point out is that it was premised on the Roundabout Theater case. And I know that's been the foundation for all the decisions that have gone in favor of the insurance companies related to the business interruption claims that have been made in New York and both in the state courts and in the federal court. Both Roundabout and the decision it was premised on, Howard Stores, both involved claims that didn't assert or even try to demonstrate any property damage or loss at the property about which the claim was being made. That is a fundamental difference from what has been alleged by BD Hotels here.
So how in this case, if we're going to go into the the weeds, how was the property insured physically changed or damaged as a result of the pandemic?
Your Honor, I think we all accept that COVID is a physical thing. Even though you can't see it, you can't touch it.
We still talk about property damage. It's property damage. What's the property damage?
The property damage that we have asserted is that COVID in an interior premise, like a hotel, attaches to property, it's in the air inside the building, and it transforms what had previously been a safe environment that could be used for any purpose whatsoever into a dangerous, potentially lethal premise. That, we submit, could qualify as either property damage or physical loss. I know this court, and a lot of courts have been down this road before, and I really, I'm not used, this was a very hard argument to prepare for because to say the weight of authority is against me, I get it. But
For now.
hopefully for now.
Knock on wood.
We're hanging on by a thread, a thin thread, but we're still trying. But so that is our argument, Your Honor. I don't really want to waste Your Honor's times. I accept where we are in the process, and we'll see what the Court of Appeals does. So with that, I'll cede to my colleague here, who's a friend as well.
Yes, close friend. Good afternoon, Your Honor. Darren McNally, may it please the court, for respondent, Federal Insurance Company. I thought we weren't going to get into the weeds. Maybe we're not going to get into the weeds on the issue. I think Mr. Ellison's correct that the vast majority of cases around the country have held that basically the presence of the COVID virus does not give rise to direct physical loss or damage. More importantly, this court has held that on 2 occasions. That's what I care about. Mr. Ellison's correct that the Court of Appeals heard decision on January 10th. I anticipate a decision shortly. The only issue from my perspective about why not stay versus just have a decision, one, I just thought judicial efficiency, we've fully briefed, now we've sort of argued. And my concern was that once Consolidated Restaurant came down, that we were going to get an additional wrath of briefing saying, well, this is how my case departs from Consolidated Restaurant. I think I just heard Mr. Ellison say, no, that's not going to happen. So I will leave up to this court how to administer your own docket, but I think we're in agreement that Consolidated Restaurants is essentially on all fours.
Thank you, counsel.
Nothing further, Your Honors. Thank you. Thanks for...
Yeah, I assume unless you wanted to agree again.
Yeah, exactly. I still agree. Thank you.
Malerba versus TA. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court. James Kirkpatrick on behalf of the appellants Tyco Fire Products. This appeal presents straightforward questions of law. The federal hazardous...
No question of fact here, counsel?
No, Your Honor. The sole factual...
So the theory, plaintiff's theory here is that the valve assembly is separate and apart from the tank, and it was the valve assembly was the or a proximate cause of what occurred here. So if that's the theory, why don't we focus on plaintiff's theory and tell me why you say that we can decide that as a matter of law, because it's at least under the CFR, it's not clear precisely how the valve and the cylinder how they're to be considered.
Your Honor, whether the valve is separate from the cylinder is found within the United States Code, not the CFR. And if we look at 49 U.S.C. 5125B1E, the word is packaging or container. So the question is this claim about a packaging or container? And we, as we cite in our brief, the plain meaning and the technical meaning of packaging or container is something that can contain. And I don't think there's any dispute here that
How
without...
does a valve contain anything?
Well, Your Honor, it's a packaging component. The cylinder was
What's the
sold...
packaging? How is a valve packaging? Packaging is something maybe that comes around a valve, it's being moved. Why should I accept that characterization that it is packaging?
Your Honor, the cylinder as a whole is a packaging, and the valve is a packaging component. Just to use one example.
It's a component. I would go that far with.
Well, then if it's a component, then it's preempted under Section 5125B1E, which
So you point to the use of the packaging components language in the statute.
Yes, Your Honor.
You explain how your theory of the case works out on the packaging components. Do I read your reply brief correctly that you really sort of acknowledge that under the CFR, the valve isn't specifically covered, but that under the statutory language, you're covered, and that there's preemption because of the statutory language, and the regulations certainly don't take force over the statute?
Well, the latter, that's true, Your Honor, but the CFR does cover the cylinder valve. Just to use one example, 49 CFR 173.301A2 states that a cylinder may not be offered for sale if it has a defective valve. So when Tyco is representing, certifying, marking, or selling the container as qualified for use in transporting hazardous materials, it is also representing that the packaging component...
So then how do you address 49 CFR 178.35C, which excludes valve assemblies from the definition of a cylinder?
Well, Your Honor, first of all, the definition of cylinder is not what's at issue here. What's at issue here is the definition of packaging and packaging component. And 49 CFR 178.3 says that a packaging is both a receptacle and anything required for that receptacle to perform its containment function. And as you can see in the record at page 352, the valve is an essential portion of the cylinder, and it could not have been represented as qualified for transporting hazardous materials if the representations that Tyco made did not extend to the cylinder valve. It would have not been able to hold anything. So Tyco's representation that it was qualified for use in transporting hazardous materials necessarily extended to the valve as well. And you know this from, for example, the Roth case. In the Roth case in the Third Circuit, the plaintiffs asserted that the tanker car should have included an additional safety relief device.
But wasn't that was something that occurred during transportation, right?
Well, no, Your Honor, quite the contrary. The plaintiff in that case argued that he should be exempt from preemption because the accident happened after transportation was completed. Even more.
Transportation. Do we have anything here to do with transportation?
Yes, Your Honor.
What's the transportation here?
So preparing materials for transportation, inspecting hazardous materials containers, these are all transportation-related functions as defined in 49 U.S.C. 5103. That's the difference.
Can you use one of these containers that could be considered preparing for transportation?
Your Honor, sorry, I'm not sure I got your question, Your Honor.
So whenever you use one of these containers, does that mean you're preparing for transportation?
No, Your Honor, that's not necessarily the case. But as we know from the Amtrol adjudication, which all parties agree is entitled to Chevron deference, it doesn't matter what's happening with the package at the precise moment of injury. What matters is, was this a packaging represented, marked, certified, or sold and qualified in transporting hazardous materials? And because it was, the United States government has an interest in governing it at all times. So states can't say, okay, well, there's a requirement on cylinder valves that occurs when it's not in transport, but when it's in transport, it's preempted. That would totally...
How long had the tank been in its location?
Well, Your Honor, not very long, a period of days. It's not relevant, again, because this is a container packaging represented as qualified for use in transport.
I'm concerned about the transportation element because that's what prompted Congress to act in the first instance, was horrific spills of chemicals and other noxious substances while they were being actually transported. So there may be some administrative gloss that purports to expand upon what is meant by transportation, but...
Not quite, Your Honor. In 1990, actually, Congress expanded the preemption provision because it found that the lack of uniformity in packagings, not just in transportation, but in packaging, so the manufacture of packagings created safety issues because manufacturers didn't know what rules to follow. So if you're creating a cylinder that holds, let's say, plutonium, and you think, okay, well, there's 50 different sets of laws that now govern what I have to do in addition to the federal requirements, that creates a safety issue.
At what point does an item, broadly speaking, cease to be in transportation, in the course of transportation?
Again, not totally sure, Your Honor. If you look at the Buono case, this is exactly the argument that the plaintiff made. He said, I was not using this in transportation. I was using this as a tool after the journey had ended to, it was called Oprandi's in that case.
But does our case involve a journey of any kind?
Yes, Your Honor.
What's the journey?
It is transported from the token booths to the joint venture to Amaron. So there is a commercial element. But again, the actual transportation is not what's at issue here. He was involved in preparing it for transportation.
When does the transportation end?
The transportation, again.
So under your theory, it never ends. It seems to be an always, it's in a...
Transportation is defined in 49 U.S.C. 5103. But we're not talking about the actual regulation of transportation. We're talking about the regulation of packagings offered for transportation. And that's exactly what this packaging was here. And so it doesn't matter. And this has been, not only has it been rejected by the Second Circuit, it was rejected specifically in the Amtrol adjudication by the Department of Transportation. The Department of Transportation said it is not necessary for us to determine whether the cylinder was in transport at the time of the incident, because at all times it was represented, marked, certified, or sold as a packaging qualified for being used in transporting.
Going back to Justice Singh's point then, that at any point then, once that label is affixed to that item, that instrument, then by at least the Federal Department of Transportation's lights, then that item remains in the stream of commerce.
It remains subject to the preemption provision. Look at the Mawa case, for example, in the Eastern District of Pennsylvania. That court found preempted claims resulting from the decommissioning of containers for scrap. So you're taking these containers, you're tearing them apart, and you're using them for scrap. That was found to be preempted. That's about as far from the actual transportation of hazardous materials that I could imagine. Here we're much closer to that. But again, under Amaron, or rather under Amtrol, under Buono, under Roth, it doesn't matter whether it was actually in transportation at the time of the incident.
Thank you, Counsel.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. The valve assembly is outside of the purview of the regulation implementing the statute, which is 49 CFR 178-61, as the Second Circuit said in Buono. That regulation governs the review of the product, the testing of the product, the approval of the product, and what product is stamp certified for use. It's marked. The question.
So why couldn't we consider? I mean, because without the valve, the tank is useless, right? So isn't there an argument to be made that it's actually part and parcel of it's one piece of equipment?
Yes, the valve assembly is part and parcel of the larger fire suppression product. However, it is not tested. It's not part of the testing that qualifies it for the mark. When the DOT tests the cylinder, the valve assembly is removed and it's replaced with test plugs.
What's the impact of 49 CFR 180.203, which but to carry out the HM defines cylinder as including valve, pressure relief device, etc. What's the impact of that on what you're telling us? The inclusion of the valve in the definition of cylinder.
There is no inclusion of a valve in a definition of a cylinder. Cylinder is defined as the container, and valves show up. For instance, in 49 CFR 178.35, I'm not sure, is that the one you're...
No, 180.203.
180.203.
That's what your adversary relies
on. If our adversary, I'm not familiar with 180.
I think it's Tycho's brief, page 23. which references that. So why doesn't...
The reply,
How do you get out of that provision?
Your Honor, the valve assembly is not inspected, it's not tested. How I get out of the provision is by looking at their own corporate representative, Newman, who said the DOT approves the tanks, the DOT does not approve the valves. And they do not at all address Newman's admissions.
Why are we bound by a putative expert's admissions in a different case as to an interpretation of a statute?
No, this is a factual matter. The factual matter is that the DOT approved the tank. It did not look at the valve. The specifications for the Ansel and the competitor Kidde fire suppression cylinders are exactly the same.
But we still have to decide what is covered for preemption purposes under the law.
Well, we can decide that there are factual issues yet remaining, and what's covered is what is stamped approved. It's what's reviewed, it's what's tested, and it's what's stamped certified for use in the transportation of hazardous materials under the DOT statute and the DOT regulation, which Buono, I rely on Buono, which is the Second Circuit ruling which addresses this defendant's own exact same preemption argument under different circumstances. In Buono, what happened was that the tank and the pressure gauge device were the components at issue, and those are covered under the regulation that Buono, the Second Circuit, said is the controlling regulation, 49 CFR 178-61, which deals with the pressure gauging device and with the cylinder. It has nothing to do with valves. It mentions a valve boss or a valve protection sleeve. Those allow the valve assembly to be installed onto the cylinder. But during the testing of the cylinder, the valve assembly is removed. It's replaced with test plugs and blind flanges. When all the measurements are taken and the pressure is measured to see if the cylinder can hold up to the DOT specifications, which are transportation oriented. Now, I agree that once the transportation function ends and the cylinder is sitting in the end user's location, the cylinder is still marked as certified for use and the preemption still applies.
When you say end user, what do you mean by end user?
Whoever the end user is, when the product, the cylinder is marked.
This cylinder wasn't at an end user location, was it?
Oh, no.
It was being sent for maintenance.
Yes, it was sent by the end user.
What happened here, that actually the valve had two safety caps, but they were removed by EA technology personnel who wanted to have spare parts. Is that the allegation here?
Yes, that's a frequent occurrence, and our client, Mr. Malerba, had no idea what you need to do, what activates the tank, what that means, and yes, an intermediary, and I think there was a prior appeal in this case where the court held that...
neither the EA personnel or the Amaron personnel were licensed to do this type of work. Is that correct?
That's correct. But the Amaron personnel weren't the ones who removed the...
It was EA technology.
Yes, I believe so. Yes, Your Honor.
So as I understand your position, sir, it's because the DOT marking was not on the valve itself. The valve, based on what Tyco's application engineer said, that wasn't tested.
Yes, if the valve assembly had been tested, I wouldn't say that, well, technically the marking wasn't on the valve itself. But the implementing regulation, which Buono, the Second Circuit, said is the controlling regulation, does not deal with the valve assembly at all. There's no test. Now,
what do you do with this cylinder if it doesn't have the valve? What's its utility?
Oh, there's no utility of it. The point is that, and their expert is correct.
One without the other is useless.
their expert is correct that if you change out the valve assembly, the approvals might be rescinded. But
How would we know that if they have different, they're supposed to have different labels on the cylinder and the valve?
yes,
If they don't, if they're not a unified entity and they're labeled for unified purposes, how would we know that that an approval was rescinded because of a safety problem with the other component?
no, their point was that their representative stated, well, I don't know if the valves were switched out and there was a different valve that was more safe, approvals would be rescinded. And their brief says that therefore that means that presumably the DOT approval would have been rescinded. But that's the incorrect speculation by the attorney, because the approvals that apply to the valve are private entity approvals, the Underwriters Laboratory approval, Compressed Gas Association. These are all on the record. The National Fire Protection Association approvals, the record at 336, 337, 340 in the Emke affirmation. That's their expert who says these are the approvals that would be impacted, or these are the private entities that control the valve assembly. Has nothing to do with the tank at issue. And at 340, Emke says that whereas the private entities govern the valve assembly, the DOT and the DOT regulations govern the tank at issue. That's a direct quote, govern the tank at issue. So and we submitted the new authorities. Hassel v. Budge shows that there's a limit to the components that are preempted and those that are not preempted, and relies on Kearns. Kearns, the factual question was, are we dealing with locomotive equipment, which is preempted, or was this equipment part of the passenger car, which is not preempted? And therefore, Hassel v. Budge said that there are factual issues remaining on the scope of the preemption.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, Brian Kalman for the third-party defendant, Amron, respondent. Basically, I could go either way on this case because I'm the third-party defendant. So I'll go one way because I was listening to the questions. So basically, if I listen to Tyco, 49 U.S.C. 1525b says the subject matter areas that include in this preemption are, amongst other things, maintaining, which I just heard that is what Amron was doing, reconditioning, repairing, or testing. Therefore, it would be preempted. I would be out as well. Mike, and if you go to the plaintiff's brief on page 6, that's what they're accusing us of doing, negligent maintenance of a product on that, so I could be out. The concern that I had is, where are we on this valve cylinder situation, and are we premature on that only because, even though the case is old, Mr. Emke wasn't identified as a witness until after the note of issue. The discovery issues that we have done some discovery on that. I'm not going to put that before the court right now because it's not part of the record, but that was my concern. How do we know that this particular tank cylinder...
Well, I guess the question I have, and because generally, at least when I've done express preemption cases, we say as a matter of law one way or the other. There is case law to say that it can be an issue of fact. What's your view of that based on what you're suggesting, that there's other testimony outside the record on this issue?
Unfortunately, it's not part of the record. I have a motion pending to enlarge the record that's pending.
We know that.
And my concern is, how do we know one way or the other whether or not this cylinder complied with the DOT standards? Usually when I represent a manufacturer, I have quality control documents. I have documents that show this is the standard operating procedure. I understand that this is from 1988. You may not have documents, but the standard operating procedure is, this is the checklist that we do to ensure that this tank, this cylinder, this valve, everything else is manufactured in accordance with the DOT. At the same time, I want to see some additional evidence that there was something.
Do you disagree with what your adversary was saying, a plaintiff, that that approval of valve assemblies is handled by private agencies or private entities versus DOT handling the markings on valves?
Trying not to, I'm not an expert on this, but we did depose one recently. If the court wants, again, I feel
nothing outside the record.
That's what my concern was, and that's why I opposed it originally. I wanted to get those answers so that I could be solidified on this. And it may be that it's tied together, and I'm out as well on this issue, but I did have some concerns when someone raises that after the note of issue and I needed discovery. That was the primary function of that. I also have some issues, and I understand the plaintiff's argument with the valve separation, which may or may not have been, depending on what the motion on the enlargement of the record shows, did make it one cohesive whole or not.
Where do you stand on the 510213 issue, the transport?
Well, that's what I'm saying. I would love it to be as expanded as possible. That's why if it's me, if Amron is preparing it for transport, then therefore Amron is out.
Help us draw the lines here a little. What constitutes transport here?
Transport, it becomes a difficult issue at this point because let's use the auto policy. We're saying at use with a vehicle. There's lots of cases before this court, and it might not be what my mother would define as transport, but if you have at use of a car, whether or not the auto policy is transferred, it's a completed operations
It wasn't
issue.
going to stay at your premises.
Excuse me?
This item wasn't going to stay at your premises.
No, it wasn't.
I mean, it was definitely
maintaining it.
meant to go someplace else.
Correct. Correct. But that's the struggle with the issue as to whether the DOT defines the transportation. When does it end? When does it not? And quite frankly, you can't, if you use what Tycho was saying, maintenance, you're not maintaining it on the road, really. You're actually having it someplace to actually be maintained. Therefore, Amron would be out under the definition. Words are not superfluous. Maintenance, I'm not maintaining it as I'm driving it down the rails or I'm doing something else. It's in a facility.
Thank you, Counsel.
Thank you very much.
Your Honor.
Is your adversary correct, Counsel, that the valve assemblies are actually not inspected by the federal government, but that's outsourced to private agencies?
Well, the record is silent on whether the federal government actually is inspecting these valves, but that confuses the various grounds on which preemption is warranted. One of them is if it's qualified for use, or rather if it's certified for use by the Department of Transportation, but that's not the ground we're moving on. Also, if it's marked, represented, or sold as qualified for use in transporting hazardous materials, it also is preempted. And it was sold
Well, what was marked here? What was marked?
The marking was on the cylinder, or rather on the actual pressure vessel. And I think the important concession that plaintiffs made during their argument is that if the valve itself was tested, they wouldn't quibble with the location on the marking. They'd say, okay, it's preempted as to the valve. But that confuses the respective role of statute and regulation. And here you have a situation where it's the Department of Transportation's choice as to what specific attributes of this cylinder are going to be subject to testing requirements. For example, not every single tank is reviewed by the Department of Transportation for testing. They say, well, we're only going to look at, let's say, 5% of tanks to make sure that they comply with our regulations. That doesn't mean that preemption doesn't apply to the other 95%. And again, the Department of Transportation could regulate valves, and indeed it does regulate valves. It says you can't offer for transportation something with a defective valve. It says, again, at 173.301, you have to comply with these very onerous standards as to valves. Now, whether the DOT actually goes out and inspects the valves or tests the valves, that's a different question, but that falls within the regulatory purview of the DOT. The HMTA's preemption provision...
The DOT says, go get it inspected by such and such a company. Does that change things?
No, Your Honor, I don't think that the DOT's inspection processes are relevant at all. The DOT could say, these are the rules, we're not going to inspect anything at all. Preemption would still apply. You'd be subject to civil and criminal penalties under the HMTA for failing to do it, but there wouldn't be a beforehand inspection. So the DOT's inspection process is a red herring, and that's consistent with the Second Circuit's decision in Buono, in Amtral, and in every case to have meaningfully analyzed this issue in the past. Now, with my remaining time, I want to talk about the other issue, which again, if the court's not inclined to engage in statutory interpretation...
Just incidentally, before you get to the other issue,
Yes, Your Honor.
Are there any federal regs that specifically deal with the valves?
Yes, Your Honor. 49 CFR 173.301. Not only does it deal with valves, so for example, at A2 it says you can't offer a product with a defective valve, but it also incorporates by reference CGA standards, Compressed Gas Association standards, that become part of the regulations, and they say the valve has to comply with those. And they also have requirements for valve safety caps, exactly like the ones that are at issue here. So there are actually extensive regulations. Again, if it mattered for preemption, which our argument is that
Do
under
you
the text
want to
of
address your other?
Yes, Your Honor, very briefly. Because again, this is dispositive. The plaintiffs throughout the life of this case have asserted that the accident was caused by the joint venture removing 2 safety devices from the valve that was, again, sold by Tyco, and that it was in perfectly safe condition and they were permanently affixed when it left Tyco's control. If you look at page 1322 of the record, in their sworn interrogatory responses, when plaintiffs are asked about any modifications to the tank, they state specifically that the safety caps that would have prevented this incident and that were permanently affixed were intentionally removed by a third party and, quote, thus launched an instrument of harm with respect to the subject tank.
Isn't the theory here that the valves, when they left the manufacturer, were inadequately recessed and the safety caps were, I think, flimsy and easily removed? If that's the claim under Hoover, isn't that really a issue for trial?
So Your Honor, on the recessed valves point, that's a bit of a red herring, because if the valve safety caps were used, you couldn't actuate it in any event. But they do sort of morph their argument and say, well, these were flimsily attached and too easily attached. Hoover is about normal wear and tear, and it's pretty uncontroversial to say if you design a safety feature, you can't design it in a way that makes it susceptible to normal wear and tear so that its functional utility is destroyed through ordinary use. But Robinson v. Reed Prentice stands for the idea that you don't have to make an indestructible safety device. In that case, the manufacturer knew that the employer of the plaintiff was going to remove the safety device. It was going to cut a hole in it. It had done a tour of the manufacturing plant and seen that the safety devices were removed. But because an intentional removal of a safety device constitutes a superseding cause, New York, thankfully, has said that you cannot put the onus on the manufacturer in those situations. Thank you, Your Honors.
Debris versus Royland.
Good afternoon. Joseph Chignosky on behalf of ROI Land Investments. Your Honors, this case deals with a series of notes which are made pari passu to note holders. There are many note holders in each series. The plaintiff appellee was one in Series B, and there are 3 other series. You'll see references both in the plaintiff's individual note to the pari passu nature of the note and throughout the agreement. In Section 6.4, which is in the record at 72, the note specifically provides that the plaintiffs can share equally in the proceeds of the collateral. Each note holder has to share equally. It's mandatory. And it's in that context that I'd like to talk to you about the different provisions that are here, which I'm sure are very confusing, laid out in briefing form. There's Section 8, which deals with the maturity date and payment. Section 11, which deals and defines events of default. And Section 12, which then provides for remedies on default. An acceleration clause, which is really the manners in which you can declare the default. And then other remedies. So under Section 12, which is in the record at 82, there are 3 ways of declaring default. 12.1a is an automatic default, if you will, based upon an insolvency, bankruptcy, receivership proceeding. 12.1b is a mechanism by which the required holders can send notice and declare an event of default. And 12.1c is a mechanism in which an individual holder can notify the company they are.
So I want you to address Section 11A, which says that in the event of default shall exist when defendant, quote, defaults in the payment of any principal or any note. And here, based on that language and then the commencement of the action, what more is necessary?
Well, what's necessary is 12.1, a 12.1 notice by the individual notice is required.
So 11 deals with defaults, right?
Right.
And what does 12 deal with? Acceleration?
Both acceleration and a declaration
So then
that it's due.
I'm sorry.
And
Why do we have to look at 12.1? Under 11A, don't you lose?
No, because 11,
No one's asking for acceleration here. You've got an individual note holder or 2 individual note holders who say they want to be paid. And how aren't they entitled to that under 11A?
12.1C, Your Honor, talks about if an 11A default occurs, then the individual holder can notify that the holds are declared.
May at its option.
Correct.
Right? So it's precatory. It's not that they must accelerate.
That's correct, Your
Right,
Honor.
That's
Exactly right. They don't need to immediately declare default. And there's many reasons, as people who represent lenders know, why you might not declare default immediately. When you're looking at the investment itself, what are the possibilities of repayment? Because repayment is only going to come from the sale of this land. And the reason why it needs to go through this Section 12 regimen is because of the rights that are given to the required holders in 12.3, which allows them to rescind or annul any such declaration. It has to run through the Section 12 process. Now, plaintiff says Section 8 is self-executing, but there is nothing in Section 8 which has anything about declaration of default or the remedies that you get in in the event of declaring such a default. In fact, the drafter specifically included in 12.1A events of default that are automatic and self-executing. And those are the bankruptcy
So
and
we're going back to the question I asked you earlier.
Sure.
Assuming you're right on this, isn't there a law in our state which essentially holds that by service of the summons and complaint, that's sufficient to meet the notice requirement? Because it's well, in that case, at least the case I'm thinking of is Freedom Mortgage, is acceleration there was made by an overt act. Here, plaintiff suit.
Right.
Isn't
So
that notice?
in that instance, Your Honor, if you were to hold that the complaint was the necessary declaration of default, then the company needs to have the opportunity to go to the required holders under Section 12.3 to seek to rescind or annul such declaration, which is the rights of the required holders. And that is the crucial difference. And then the other section that we're talking about is regardless, the required holders have waived this event of default. And that's how we move to Section 17. In the discussion of that section, I think what's crucial, and that's at the record 86 and 87, is no amendment, or it says that the required holders can amend or waive provisions. And what's not put into the briefing, but it's very important, is Section A gives a laundry list of events on which no amendment or waiver can ever happen. And then there's Section B. And Section B says, subject to Section 12, relating to acceleration of...
And again, I want to stop you. Acceleration here didn't occur, right? So
acceleration in the form of a declaration didn't occur.
So why not just look straight at the language of 17B? No amendment or waiver may without the written consent of each of the holders at the time outstanding. Doesn't that end that argument?
No, because if you invoke Section 17B and you amend it, it has to be subject to Section 12. Section 12 contains a specific provision allowing the required holders to rescind and annul a declaration of default. And that never occurred here. And that's the important part of that section. If it was, as the plaintiff is reading in the court below read it, just ignore the language about subject to Section 12, it could have just been in A, right? There's no reason to have a separate section. What's laid out here is the importance of running the process through Section 12. And if you don't run the process through Section 12, you essentially vitiate the rights of the other note holders who are held pari passu, who are holding pari passu, because the company cannot pay out an individual note holder without breaching their agreements with all the other note holders. All the other note holders need to be paid at the same time. They need to be treated equally under their agreements. I see my right is led, so I'll yield my time and come back.
Thank you.
May it please the court, Matthew Barnes for plaintiff respondent Regine Debris. I think, and I'll try to be brief for the panel, I think that this case underscores the importance of understanding the context upon which their ROI in this case could be held in a default, and understanding which one is which.
What's your response to his last point about Section 17B, that it can't just mean that you don't need a written consent at any time outstanding, and that because then it could have been included in 17A, and why do you have a separate 17B? Referring to the Roman numeral I, subject to Section 12 relating to acceleration or rescission.
My response to that, Your Honor, is that I think appellant's entire case rises and falls on whether or not Section 12 in this matter is actually applicable, and I respectfully submit that it is not. The Section 12 has no applicability here because, again, this was not the path that my client chose to proceed. She did not. Actually, Section 12 speaks to a situation where a holder of a note decides to accelerate all the notes, and he keeps making that point. It keeps using that language in Section 12. My client didn't seek a default on all of the notes. She relied exclusively on the rights that are embedded in the agreement. This controversy respectfully implores a review of only 3 sections: Section 8, Section 11, and, to counter the argument made, Section 17B. And the court made an extensive analysis and concluded that under no circumstances could another person, on behalf of my client, a required holder or otherwise, amend any of the 3 enumerated types of changes enumerated in Section 17B, most notably the time for maturity of these notes, which is Section 8. So the answer is that there's no getting around that Section 17 limits a required holder's ability to amend the maturity date of my client. Panel has any questions, I'll rely on my brief.
Thank you, counsel.
Thank you.
I think the answer to that is very clear. There's no self-executing provision of Section 8. Section 11 defines the events of default. Section 12 defines the ways in which you can declare default.
But I just going to say, I'm confused with Section 12, or at least your argument about it, because it's entitled acceleration, and then it discusses defaults arising from events such as bankruptcy or receivership. All notes then outstanding shall automatically become immediately due and payable. How does that apply to what occurred here?
There is no individual default. A declaration of default for one note is a declaration for all notes. The notes are held pari passu. Because they're held pari passu, when one note is declared due and payable, and therefore the company must pay.
Isn't there a situation where in order for you to effectuate an amendment, you needed every note holder to consent?
Yes, 17A, not 17B. Correct. And 17B.
Yeah, but 17B also speaks no amendment or whatever
Right,
made
but
without the written consent of, and that must be a typographical mistake, without the written consent of each holder.
Right. It's that 17A. And then 17B says, subject to Section 12 relating to acceleration and rescission. And what they're trying to do here is say, if you're going to do anything that affects the time or payment, such as a maturity date, you have to run through the Section 12 process. And the required holders, as they have here, need to act and waive the event of default.
Well, would that render 12.1C Romanet 3 meaningless then?
12.1C.
Romanet 3?
Roman head 3?
Can it amend any of Section 8 and then Section 11, but Section 8 would be the operative section?
Oh, Section 8 uses the term maturity date. And then if you look at Section 8, what it says, it can be extended for a period of 18 months, and then uses maturity date, capital M, capital D. You look at the definitions at 264, 265 in the record, what you'll see is the maturity date is one that will be extended from time to time. So it was always anticipated, as a maturity date is defined, that it's a maturity date that could be rolled over from time to for 18-month periods. But the only way that you can do that after the initial 18-month period is to have the required holders act. And in this case, they've done. And Your Honor, I see that I've got the red light, but I'll point out this is a very important case. I realize the dollar value is not high, but what is important is there are a lot of other note holders who are out there who are at risk. And I realize plaintiff says, I don't care about them. But the reality is everyone has to share equally in what happened here and what is essentially a land investment. And the company is struggling to put themselves in the position under this agreement to pari passu pay out as much as they can to all the note holders on an equal basis. And what plaintiff is trying to do here is circumvent the effect of Section 12.3, which allows the required holders to annul or rescind an event of default. Thank you.
Thank you. People versus Torres.
Good afternoon, and may it please the court. Rosemary Herbert, Office of the Appellate Defender, on behalf of Victor Torres. The frisk of Victor Torres was unlawful where the police had no basis to believe that Mr. Torres was armed or posed a danger to them. The legal standard here is very well established. In order for the police to conduct a frisk, they must have reasonable suspicion that somebody is armed and poses a danger to them. This is established by our Court of Appeals, by the United States Supreme Court. Yes, Your Honor.
You see that I'm about to ask you a question.
I do.
Isn't that satisfied with some of the what came out in testimony? For instance, that it was dark, that the defendant, it was like speaking to a wall, was not responsive, that there was furtive movement in the car, that the windows that were up, that were down were all of a sudden rolled up. Isn't that enough?
No, Your Honor, absolutely not. Those indicia, which were the darkness and the time of day and the non-responsiveness, were cited by the court below in upholding the validity of the frisk. But again, those factors they don't go at all to the fact that Mr. Torres posed a danger to the police.
Well, maybe that by themselves, when you couple them with the windows being rolled up and then the furtive movement inside, doesn't it get you closer?
Well, the windows being rolled up did not factor in at all. As I understand it, as the car was observed driving past the police earlier, they were down. By the time the car was stopped, and there's no indication they tried to evade the police, the windows were rolled up. They were asked to roll them down, which they did. So I think that doesn't factor in at all. But
And how about the failure to produce identification when asked for? Is that also an element? Sort of, I think or at least the argument is totality of circumstances.
absolutely, Your Honor. I recognize that it would be totality of the circumstances, but absolutely not. And there's no.
Well, how many more factors do we need? I mean, when do we? You say that the frisk is okay then?
Well, you would need something that could reasonably be linked to an indication that Mr. Torres was armed or that he otherwise posed a danger to the police. Here you have nothing. You have a routine car stop.
The vehicle was shaking? Am I mistaken about that? Vehicle was shaking?
There are 4 people inside the vehicle, and there was testimony that the vehicle was moving, but that
was nervous?
As many people are, in which this court and other courts have recognized is an entirely innocuous factor, that in other words, people are often nervous when stopped by the police. But you don't have what you have in other cases where frisks have been upheld, where you have somebody reaching to grab an object, where the police see the outline, the bulge of something that could be a weapon. You don't have any of that here.
If they think that there may be PCP present in the vehicle and they ask them to step out and they're contemplating, well, maybe this is going to escalate to an arrest situation, under all the circumstances here, they wouldn't be permitted to do a pat-down?
No, Your Honor. The fact that, and again, the court has been quite clear, one of the cases cited in our brief, Gonzalez from this court, basically if the offense that is being suspected is a drug offense, something not connected with a violent crime, that does not provide the police with a basis to conduct a frisk. In that case, in the Gonzalez case, somebody matched a description of somebody who had been engaged in drug sales. When the police car approached this person, they fled. And they said under those circumstances, absolutely not, there was no basis to conduct a frisk.
So if they think they're going to make a drug arrest, they're not permitted to do a pat-down?
Well, if they had probable cause to arrest, they would, of course, be able to do a search incident to arrest.
It's a lawful arrest. But so the officer's subjective thinking that this might be an arrest situation, is that sufficient to authorize a pat-down?
Not unless there is probable cause, no. I mean, I think in many
respects... probable cause, it would go further than a pat-down.
Absolutely, absolutely. And again, I think that it is often, based on my review of many, many records over the years, it is often treated as the two are the same. If you have reasonable suspicion, you can conduct a pat-down. But that is not the law. And I would note that distinction has been codified by the legislature.
Reasonable suspicion to stop.
Right. You could.
This was 2 separate acts, right?
Absolutely.
Stop and frisk.
And here I believe that the officers were treating them as one and the same. And certainly the fact that there was a traffic...
officers are presumably not lawyers, and they're dealing with this rapidly unfolding situation. at night in a dark area under the circumstances that the trial court apparently credited. In a rapidly unfolding situation, we are, the five of us, along with both counsel, are dissecting this in the comfort of an office. I mean, are we giving enough attention to the fact that all of the confluence of all of these factors in a short period of time to individuals who presumably weren't lawyers?
Well, Your Honor, I think it's very significant here that at no point did the officers testify that they feared for their safety.
Well, I would take issue with that, actually, because on page 35, Officer McDevitt says at that point I had him step out of the vehicle just for my safety after I felt he wasn't compliant enough with the driver's license and registration and insurance. And then on page 37, he says, and you said he was unable to produce his license and registration. Answer, that's correct. Did you make any other observations of Mr. Torres while he was in the car? Answer, nervous, fidgety, were his hands placed on the steering wheel? When I asked him for any of his driver's license registration, there was like no attempt, almost like talking to a wall. Did he leave his hands on the steering wheel? At one point, he took them away from the steering wheel. I told him to keep it on the steering wheel.
Again, I don't, in what Your Honor has
So
read.
he does specifically mention the safety factor on page 35.
To me, it reads as if a recitation of, I did that for my safety, but you have to have a basis to be concerned for your safety, and that is completely
Going back
lacking
to what
here.
my colleague brought out before, late at night, under a bridge, the defendant acting strangely, not producing identification, totality of the circumstances.
Those are not sufficient circumstances based on the precedent from this court and from the Court of Appeals. And I would note also, with respect to the time of day, I mean, the darkness and the location of the stop, that was dictated by the police. I mean, they chose when to pull this car over. They also dictated where they actually
Well, it wasn't
conducted-
dictated by the car with loud music being
But they
played?
followed it for 2 blocks. So again, they certainly could have picked a location, and specifically with respect to the pat-down, they directed where that would occur. They asked Mr. Torres to step out of the car. There's no indication that he didn't comply with that request. And they also brought him to the rear of the van. They have lights, flashlights, so they dictated those circumstances. So it can't then be used as a factor indicating a fear for their safety. Thank you, Your Honor.
Counsel.
Good afternoon, Your Honors. May it please the Court. Jennifer Cavaias for the people. At the suppression hearing,
The lower court wrote that, for the most part, it credited the officer's testimony. And for the most part, it did not credit the testimony of the defense witness. But it didn't specifically say what it credited and what it did not, correct?
that's correct. We don't know for sure what the court meant by that, but in the following statement, the court talks about the PCP and saying, putting that aside, there's enough here to substantiate
Probably
the-
putting the PCP aside is because of the line of cases that say that drugs doesn't necessarily mean you're in fear for your safety, right? It doesn't equate violence with drugs.
Correct. And here, the officers had enough to have fear for their safety, given what you were talking about before with the
But what is, if we dissect it, I know that the totality of the circumstances, you want to give the benefit of the doubt to the officers, but that's not the law, right? So what is it specifically about this encounter or events in this encounter that led to the rise? Because a person not turning over license and registration, that's not it in and of itself, right? A person being nervous, that's not it in and of itself. What is it?
I think the best way to answer your question is to just go step by step with how this encounter unfolded. First, when the officers perceived this car and saw it driving, the windows were up and it was tinted windows. When they pursued the vehicle after hearing,
Actually, the windows were down, right?
they were up, and then when they couldn't. No, yes, you're correct.
The
They
music, they were down.
The music, they were down, and then the front windows were tinted. Then the officers pull over the vehicle. Now the windows are up, and they see this vehicle shaking back and forth. In a bunch of cases, we know what that could mean, that they're reaching back, that they're trying to move around. It could be a variety of things that officers, in their experience, have assumptions of. Then they approach this car. The officer that's speaking to the defendant says, "Can I have your license and registration?" Like Your Honor pointed out, the defendant did not engage with the officer at all. It was like talking to a wall.
How does Molina figure into this? At what point did the police become aware that there's Molina in the car, and they have a prior history with Molina, it's obvious? Where does that figure into all of this?
I would submit that Molina's presence in the car is irrelevant to the officer's conduct with defendant. It was defendant here that posed a safety risk to...
But they know Molina as someone who has prior dealings with the police about PCP, right?
That's correct, but defendant himself was the subject of this arrest, not Molina. Molina was present.
I understand that, but this seems to escalate, or does it not, when the police, whether it's McDevitt or Galarza, become aware of Molina being in the car?
Well, the testimony regarding Molina and the exchange that the officer had with Molina, that wasn't in the defendant's testimony, and the officers didn't discuss that in their testimony at all. That didn't come up at all. So it is our position that that could be something that the court reasonably didn't credit. We don't know for sure.
Don't know because the court didn't say.
Exactly. We are unsure. There's not enough on the record to attribute anything to that interaction. But notwithstanding Molina, this interaction with defendant alone gave the officers reasonable suspicion that...
How do you answer your friend's point that the police could have dictated that the stop of the vehicle occur, or at least the frisk could have occurred in a more well-lit area or in the presence of other officers, something that would have mollified the officer's safety concerns?
Well, I don't think that where the officers stopped them was just one factor. The factor that really gave the officers concern here was that the defendant was not responding to anything that the officer had to say, and also spontaneously removed his hands from the steering wheel, and then he asked them to get out, and that interaction was already speaking to be unsafe. The darkness...
In other words, he asks for the license and registration. There's no effort to produce the license and registration, but he does move his hands.
Yes, exactly. And then with all the factors that the officers had already seen, that it's dark.
What does that mean, that he moved his hands?
Well, the officer said, keep your hands there, and then on the steering wheel. Then the defendant moves his hands. Nobody knows why. The record isn't clear why he moved them, but the officer said, put your hands back on. And the fact that the officer...
And then what happens?
And then he
puts his hands back on?
The record isn't clear about what happened exactly with where the defendant...
There's a lot has been said about the defendant not responding. The defendant doesn't have to respond, does he?
No, the defendant does not have to, forwardly engage with police, but the fact that he's not even engaging with police, not even acting like the police are there, not responding, removing his hands...
That just means he's disregarding them. How does that mean that he's a danger?
Well, the officers have the right to ask questions after there's probable cause for this. There's probable cause.
And the defendant has a right to not answer.
Yes, but the totality of all the circumstances here, not just defendant not answering, gave rise to reasonable suspicion, like all your honors have been alluding to, the fact that it's dark, this conversation with the defendant, or lack of conversation, the vehicle shaking, all of these things taken together.
I would tend to agree that the totality of the circumstances here would tell an officer something's not right. But does it tell an officer I'm in danger?
Yes, it does, and the officer directly testified to that on page 38. On cross, the defense counsel asks, did you conduct this pat down because you were for safety or for safety concerns? And the officer says yes. So during this suppression hearing, it came out that the officer had concerns for his safety, conducts this pat down, feels something in a sock that in his experience could be a weapon, and then removes that item because he believes, this could be a weapon, and then we have the arrest. So in the officer's experiences, this is a completely logical happenings here that reasonably led the officer to believe that his safety was at risk. There's no further questions. We ask that you affirm.
Thank you, counsel. 2 minutes, counsel.
Very briefly, Your Honors, the testimony that my colleague referred to, it's simply a recit. He's not asked if he was concerned about his safety. He simply recites that he removed him from the car for his safety, which as part of a traffic stop, he is allowed to do. We don't take any issue with that. The question is whether he's allowed to frisk him, and there is simply nothing on this record that provides any reasonable suspicion.
Also, there's a distinction to be made that an officer has the power to ask someone to exit their vehicle during a car stop.
Yes.
That does not mean that the officer has justification to frisk.
That's right. And as the court has said in other contexts, the right to frisk is not automatic. Simply because you have some basis to stop somebody, in this case a traffic stop, simply because you might have some suspicion of criminal activity not connected.
What are defendant's options when asked for his license and registration?
He can either produce the license and registration, or he can not respond. And actually, with respect to that,
not responding, there's a consequence to that, right? I mean, you have to produce.
He could be cited for failure to produce a license, absolutely. But again, I think in this situation, people are often afraid, nervous. There may have been a language barrier here. It may be that he didn't immediately understand what the officer was asking him to do.
So if the, how would someone ever be charged with driving without a license if there is an option of not producing the license?
I'm sorry, I don't understand the question.
You're saying he doesn't have to produce his license.
Well, there is no requirement that he produce a license, although he may suffer consequences if he does. I would note here that ultimately the way this unfolded, there was no question about the appropriateness of the registration of the vehicle, or I believe their license. He was not cited. There was no claim that he was in fact driving without a license. So it's certainly under the whole circumstances.
We're into that subject because the testimony is that the defendant was asked for this and he doesn't respond to it.
He didn't respond immediately, and with respect to this...
That's not what the testimony says. It just says he didn't respond.
That's correct, and there is actually no testimony that prior to being asked for his license and registration, he was ordered to keep his hands on the wheel. And at some point, the officer does note that he moved his hand, which perhaps could have been to obtain his license and registration. And that's the point where the officer decides to get him out of the vehicle. I would also just note that it is an objective standard. In other words, whether these officers might or might not actually have been afraid is not the issue. The issue is viewing the totality of the circumstances, whether there was a reasonable basis to conclude that they should have been. Thank you.
What he says was, when I asked him for any of his driver's license registration, there was like no attempt, almost like talking to a wall.
That is certainly the testimony, but again, there's no connection between that and a reasonable suspicion that he was armed or posed a danger to the police during this encounter.
Thank you, counsel. Thank you both. Marjan International versus Lillian August Designs.
Good afternoon. May it please the court, Michael Gibson on behalf of the appellant Marjan International. Your Honors, this appeal arises out of the trial court's, in its own words, reluctant denial of Marjan's motion for summary judgment in lieu of complaint on a promissory note executed by respondent Lillian August and personally guaranteed by its principal, respondent John Weiss, who I note has not opposed this appeal. Your Honors, there is no dispute that Lillian August executed the promissory note, which provided for its unconditional obligation to repay the sum of $1.5 million. The note makes no reference to any performance obligations on the part of Marjan. It provides for no conditions to Lillian August's obligation to repay the entirety of the loan, and it makes no reference to any other agreements. The key portion of the note, Your Honor, and in the same language, the substantive language is also contained in the guarantee, is the following. Borrower acknowledged that this note is an instrument for the payment of money only within the meaning of New York CPLR 3213.
So let me ask you this. So that's what the note says. And so that's language that maybe should be enforced. But if you look at the underlying statute, 321113, instrument for the payment of money only, isn't there an argument to be made that the note also has contingent tax obligations, I think? Would that put us outside the analysis of how traditionally we do a 3213 motion? And would that change the result?
Your Honor, I believe it would not. First of all, I note that we are not seeking to recover any taxes in this litigation.
I understand that, but that's neither here nor there.
Absolutely, Your Honor. But the answer is no. The law is clear that the parties can go the court can go outside of the note itself for de minimis extrinsic evidence to fix a sum. For example, attorney's fees. This court has seen plenty of promissory notes. You'd be hard to find one in commercial context that does not have attorney's fees. In order to fix that sum, of course, some extrinsic evidence is necessary. And for the same purposes, if we were attempting to collect the taxes associated with this note, it would have required de minimis deviation from the note itself and would not take it outside the purview of 32.
Oh, you believe even if you were trying to collect taxes, you would still be entitled to 3213 relief here?
I do believe so, Your Honor.
Okay.
Your Honor, and I just to close the
Is that based on 3213 or on the waiver?
I believe both, Your Honor. I believe under 3213, if we were seeking.
How would you establish, if we're going to go down this road, how would you establish your contingent tax liabilities based on the agreement itself?
just as we would with attorney's fees, for example, Your Honor, when we would have to go to our legal bills and present those legal bills to support the attorney's fees, we would go extrinsically to a tax liability, and that's a fixed sum that could be presented to the court to establish that. And again, that's a de minimis deviation from the instrument. And Your Honor, just to close the loop on the 3213 acknowledgement, respectfully, that was a material clause that was bargained for by the parties in order for Marjan to loan the sum of $1.5 million. And respectfully, Marjan was robbed of the benefit of its bargain to simply have that blue penciled out of the agreement by the court below. And New York law is clear that parties can chart their own procedural course within contracts, such as 3213 provisions, arbitration clauses, so on and so forth. But I want to touch, Your Honors, on the crux of the respondent's argument and why I believe the court below declined to advance 3213 treatment. And that's this argument that the court needs to go outside of the note and the guarantee to determine the parties' obligations and rights thereunder. And specifically, Lillian argues that the court
Because
must...
you had this consignment agreement, did you not? And there were amendments to those agreements, and those amendments affect the payment, the timing of payments. So doesn't it take you outside of the note?
I don't believe it does, Your Honor, because those amendments, first of all, to be clear, the consignment agreement is not referenced anywhere in the promissory note or anywhere in the guarantee. The amendments to the consignment agreement only did one thing as it pertains to the notes, which was to give Lillian August more time to make their payments at their request, and which they nonetheless failed to do. That was the only impact that those amendments had on the notes. Did not do anything to take it out of 3213, Your Honor. And simply put, the consignment agreement is a red herring. It has nothing to do with this claim. There were no claims brought under that consignment agreement. The lawsuit is under the note and under the guarantee. There are no conditions to the respondent's obligation to make payments under those instruments. And lastly, Your Honor, I see my time is up, but the second argument as far as attorney's fees, we've already touched on. Thank you, Your Honor.
Andrea Rochelle for respondent. Lillian August. First of all, counsel mentioned John Weiss not opposing the appeal.
How do you get past the fact that you've agreed to have this treated under 3213? I mean, this was bargained for, presumably. Presumably people were counseled, and you had to know what you were opening yourself up to.
Well, this actually also goes to a statement that counsel just made, which is that the lower court stated something like it was constrained to find against the appellate in this case. And the reason for that is because the court could not find from the face of the instrument sued on the provisions that would allow it to determine what was due. And for counsel really to say that the consignment agreement has nothing to do with this case is really cute by half. Because the promissory note...
Is the consignment agreement referenced in the note?
Say that again, I'm sorry?
Is the consignment agreement referenced in the note?
No, but the
So
note
going
is
back to my
referenced.
colleague's original question, in order to get this money, you agreed, didn't you not, that the note and guarantees are instruments for payment of money only? And does that end our analysis here based on that contractual term?
Well, the court below felt that it was entitled to engage in an independent determination as to whether or not the...
Well, I guess the answer is no, that the contract means nothing, that your agreement to treat it as 3213 means nothing?
This is one of those agreements because the parties were so... the transactions were so complicated and the documents, the financial documents, were so inextricably intertwined that the court was constrained to find that these were not
for a second. Let's forget about what the trial court did.
Okay.
Okay? We have this particular guarantee that makes explicit reference to 3213 and has a covenant in there that the parties agree this is going to be an instrument for the payment of money only. So why isn't that particular contractual provision in the guarantee enforceable?
Well, I'd like to know how the court below, or this court, could determine, for example, interest. Because although the note said that, that no interest would be imposed, the consignment agreement and the amendments to the consignment agreement show that they were going to be collecting interest in the form of this 5% sort of tax on top of drugs and other goods that were being consigned. So there are really questions of fact here as
And
to
what are the questions of fact?
many, many questions of fact.
I'll take one.
I'll give you one. If you'll give me 1 second. First of all, there are different dates as to when the appellant contends payment stopped. That's one. How interest was accounted for, that's another one. If you look in the consignment agreement, the amendment to the consignment agreement, you will see that the payments and the due dates for the payments are changed. You won't find that on the face of the promissory note.
But this, again, goes back to our concern is, well, now we're straying from the guarantee and the note to find other terms. But if we've agreed that this constitutes an instrument for the payment of money only, and we've charted that course, what difference would that make at that point?
I don't think that the court can reasonably simply ignore the consignment agreement because it overwhelms the note. It discusses the note and the payment terms under the note and changes those terms, and especially with respect to the second amendment, which makes dozens of changes to the payment
Did
terms.
Lilly and August make any payments after January 20th, 2021?
January 20th, 2021.
Isn't that the date of the last payment when $15,000 was paid? And then after you work it through, doesn't it leave you with the fact that $870,000 remains an outstanding principal?
Well, there's a discrepancy there too, because appellant argued below that there was a default that occurred on November 2nd, 2020. However, in the appellant's brief to this court, appellant alleged that payments ceased after January 20th, 2021. So there are many discrepancies which would not allow the court to simply forget about the...
Wait, we're in agreement that no payment was made after January 20th, 2021?
I believe that that is the case.
So at the very least, wouldn't they be entitled to summary judgment, at least on that amount? I know you have issues with interest, but what would your argument be why they wouldn't be entitled to summary judgment for the balance?
So you're saying, Judge, that we wouldn't be computing interest because we can't compute interest given the vagaries of the interest provisions here. So it would just be as to the principal?
So the note itself says no interest unless event of default, correct? The note says no interest unless there's an event of default. So in
Except
this
that-
case,
yes,
there's an event of
except
default.
that's contradicted in another document.
And in this case, there was an event of default. Does the note then go on to say what the interest rate is?
The note does not, but the consignment agreement does.
Okay, thank you.
Coming back?
Your Honor, to answer your question, the note
I thought I
does...
saw there was some issue whether they had paid $630,000 to $650,000. Is that an issue? And if it is, how do you get past that?
Is this for me, Your Honor, or for...
It's for you.
Okay,
For
I'm
you.
sorry. Your Honor, to answer that...
Because your claim is that $870,000 remains unpaid.
That's correct, Your Honor. And if there is...
I know I'm not letting you answer my first question, but how do you deal with her point about how are you computing interest now?
Well, to that point, Your Honor, the interest is very clearly provided for in the note.
How much?
The note says, commencing 5 days after the occurrence of an event of default, without any way affecting holder's right to accelerate this note shall bear interest at the rate equal to 8%.
So what's
per
the
annum.
date of default?
The date of the last payment.
You say January 20th, 2021 is the date of default?
I believe so, Your Honor. And Your Honor, to the point of to the extent that there's
What about the 630, 650,000 discrepancy, if I have those numbers correct?
I don't think so, Your Honor. I think there was a total payments of 450.
They didn't claim they paid a
I'm
total
sorry,
of
no,
six-
Your Honor, I'm sorry. The last payment that I believe was made was in November of 2020, which was, there was an amendment that I believe was supposed to split out a $150,000 payment that was supposed to be made on November 1st, 2020, to have $50,000 paid on November 2nd, $75,000 paid on November 16th, and $75,000 to
So
pay.
now we're going to outside documents, right? Don't do that, counsel, please. Thank you. Now we're going to outside documents?
Well, no, I don't think you're going to outside documents, Your Honor. And it's,
Your brief at page 10 says Laddie admittedly did not make any payments to Marjan after January 20th, 2021, and the $15,000 payment made on that date was a late partial payment of the $50,000 reduced installment due on November 2nd.
yes, and Your Honor, what the answer to the question is, we firmly believe that the evidence that was submitted to the trial court in support of a summary judgment establishes the amount that is due. But if there is any factual dispute that's raised by that, it would have been appropriate for the court to grant summary judgment and set the matter for an inquest on damages. And as a matter of fact, counsel pointed out, questioned where Justice Ostrager's reluctance was. Now, I certainly don't want to speak for Justice Ostrager.
Yeah, counsel, I just want to understand, in order to calculate interest, do we have to go to beyond the note and into the consignment agreements?
No, not at all, Your Honor.
Okay.
Thank you, Your Honor.
Thank you. Whenever you're ready, counsel. You may proceed.
Thank you, Your Honor. May it please the court, my name is Harry Lippman of Rottenberg Lippman Rich. I represent the appellant Jackie Shu. The decision we're appealing from held that an employer may terminate an employee without cause and then take away his valuable post-employment benefits, in this case almost $2 million of what are defined as equity units in the papers, valued in 2014, based on flimsy claims that he breached what is by any measure a patently unreasonable non-compete covenant.
So I guess that's the first question, and I think I already know the answer. So under Delaware law, is a forfeiture for competition viewed as just as a straightforward contractual obligation, and further, not reviewed for reasonableness? Because you're arguing reasonableness here.
Yes, in the briefs we argued based upon the Chancery Court's decision in Ainsley, which 2 weeks ago was reversed in a decision by
So what's your argument now? We're familiar with the case, but what's your argument now?
So no Delaware, I have sort of a bipartite argument. First, there is still room under Ainsley for a situation where the employee is terminated without cause. Ainsley involved Cantor Fitzgerald partners who voluntarily left the company and immediately, or within a year, started competing. So they knowingly, voluntarily rather, left the company. In this case, very different. The employee was terminated without cause. Now, under Delaware law, where I think is the proper place to start, because this court must make a prediction as to what the Delaware Supreme Court would do with this case under these facts. Under Delaware law, there is no case that deals with the termination without cause of an employee under these situations. And that's why the Chancery Court case
But why should it matter
covered that.
whether the employee left, though in that case it's different with a partner as opposed to an employee, but left as a on their own volition, or in this case terminated without cause?
Well, I have ample authority from New York as to what
We're talking about
the
Delaware.
difference is.
We can talk about New York
Well,
later.
under Delaware law, it's unclear because Ainsley is distinguishable, and as I said, there is no Delaware case on point. But where Delaware stands right now is very similar to where New York State stood about 40 years ago before the Post v. Merrill Lynch case in 1979. Before Post v. Merrill Lynch by the Court of Appeals in 1979, there was a case called Christ. We didn't brief it because we didn't have to because Ainsley hadn't been reversed yet. But the Christ case was very much like the new Ainsley case. And Post v. Merrill Lynch from the New York Court of Appeals provided an exception to the situation where the employee choice doctrine held. The Christ was the case in New York State where the employee choice doctrine said that if the employee voluntarily leaves and chooses to compete, then the employee can lose the benefits without any review for reasonableness. What Post v. Merrill Lynch said is no, not where the employee is forced out, which was the issue in Post. And in resounding language, the court said that it would be unconscionable for a forfeiture to be allowed by the courts where the employer severed the employment relationship.
But now, to Justice Singh's point, wasn't the material distinction that Cantor Fitzgerald was making was between the forfeiture for competition on the one hand and the restrictive covenant on the other? It wasn't so much a matter of whether the employee left voluntarily or was terminated, but we're going to distinguish between those two types of contractual arrangements.
Your Honor is absolutely right, but the Ainsley court was not faced with a situation where the employer threw the employee out, and that's what happened here. Mr. Hsu was, and there's no real dispute about this. You can read the papers clearly on this. I won't go into the details as to why there's no dispute. They seem to think there's a dispute that the employee was terminated without cause,
So what's the
but
Delaware
he was not
law
terminated
case?
here.
What's the Delaware case? Because that's what, I always struggle with. I struggle with our law, and I struggle even mightily with other states' law. So what's the Delaware case that you say is most favorable to your position today?
There is no Delaware case on point. So if this court predicts that the Delaware Supreme Court would stick by its contractarian principles even where the employee is terminated, then we have a big problem here because we're in New York, and under New York public policy, such a foreign law is repugnant. And I cite Brown and Brown in our papers for the proposition that a foreign state's law with regard to restrictive covenants, and in that case it was Florida law.
Well, here it was 18 months, right?
Sorry?
18 months. He couldn't compete for 18 months?
18 months.
And he was going to get about close to $2 million for staying out of the market for a year and a half.
That's right.
And you
Postponing
say-
his
hold on,
career
hold
for
on.
18
and
months.
you say that New York courts would say that that is a draconian provision?
I think if a New York court looked at this non-compete provision on several grounds, would it find it patently unreasonable. The duration of 18 months is unreasonable because under the employee's actual employment agreement, there was a six-month prohibitory non-compete. Sorry?
Is the test reasonableness or repugnancy to our public policy?
Well, the test with regard to rejecting a foreign law is repugnancy. And I would say we more than satisfy repugnancy here because if you read Brown and Brown, which is a 2015 Court of Appeals case, it rejected Florida law, which is very analogous to what the Delaware Supreme Court law would be if Delaware Supreme Court were to reject my client's claim here. And we cite Post for New York's strong public policy, which you need in order to find repugnancy. We cite Post v. Merrill Lynch, which has a progeny of cases over the past 40 years, no exceptions where when the employee is asked to leave without cause, then the covenant has to be reviewed for reasonableness. And to Justice Singh's question, the unreasonableness of this clause is, we describe it in the papers, but really it would prevent, for example, my client from becoming a janitor at a competitor. It would prevent my client from going to an affiliate of Castleton Commodities, even if that affiliate had no relationship whatsoever in terms of the business that it does with Castleton. It also would prohibit my client from doing that anywhere in the world.
Would your client have gone into some other kind of trading that has nothing to do with what he was doing for his former employer?
Maybe, but he would not have had to under the law of the state of New York, and I believe also what you could find is the law of the state of Delaware.
So that sounds like what you're arguing is reasonableness, and not that it's repugnant of our law, isn't it? Isn't that what the argument seems to be?
Well, I think it's as repugnant of New York law as Florida's statutory scheme was under the Brown and Brown case. I don't think there's any difference between the Florida statutory scheme, which favored the employer, and a possible decision by the Delaware Supreme Court, which would favor the employer here and restrict trade. Because we have to remember what Post v. Merrill Lynch said, and its progeny amplified, is that the restraint of a forfeiture for competition provision can be just as real as a court injunction prohibiting someone from going there. If I feel restrained by $2 million worth of benefits not to compete, well, that's tantamount to an injunction in effect, and that's exactly what Post v. Merrill Lynch stands for in terms of equating forfeiture for competition clauses when the employee is terminated without cause with your run-of-the-mill employment agreement restrictive covenant.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Craig Kesh for the respondents, Castleton Commodities International. Based on what my adversary said, let me address the cause or without cause, because that is something that Mr. Lippman harps on. And he says that if it's without cause, you do a reasonableness test. Well, first of all, as Your Honor said a moment ago, that is not what the law holds. In fact, the Hall case in Delaware, the Ainsley case in Delaware did not turn on whether an employee was terminated with cause, without cause, what have you. And in fact, the Pollard case, which Mr. Lippman omitted, essentially is addressed by the Delaware Supreme Court in Ainsley that says, in Pollard, the Third Circuit said that it believed what a Delaware court would do in the situation where there was an employee that was involuntarily terminated and then went to work for the competitor. And yes, in Pollard in 1988, decades before Hall, what the Third Circuit said, it believed that Delaware would apply a reasonable test, and the Ainsley case a few weeks ago said in footnote 102, actually, with all due respect to the Third Circuit, we would not. The second thing is there are multiple distinctions between the cases that Mr. Hsu cites, and a lot of those distinctions relate on whether this compensation was earned money and whether it was a part of an employee's salary or a bonus or they put it into a deferred compensation plan. None of that is the case here. This was not a salary, not a bonus. Mr. Hsu made plenty of money through salary and bonus. Right? This was a totally, essentially free reward. He did not even purchase the units. It was a voluntary plan, not the case in some of the other case law, right?
Well, in other words, if he hadn't accepted this gift, he could have gone and competed, right? I said if he hadn't accepted the gift, he could have done whatever he wanted. The voluntary nature of the...
Well, not only that, but he could have remained in the position he was at the company. In other words, this was not... this award of units was not at the time he was employed. This was at a subsequent time. He was under a contract. So he could have said, thank you, but no thank you. I'll just remain, where I am. I've got the salary. I've got the bonus. And then, yes, Your Honor, he could have then left when the contract was up or before, which actually leads into the next point, is that the without cause is a bit of a stretch. It was a contract that expired by its terms, and it wasn't renewed. What happened was the company agreed to treat the termination.
Yeah, but I'm not impressed by that argument. It was without cause. So the question is, does it matter if it's without cause, employee, a partner voluntarily leaving a partnership? Is there any distinction between those scenarios?
No. No, because Ainsley has said, the Delaware court, the conditioned payment device, initial caps, which is what was at issue as applicable here, operates regardless of why the former partner was no longer a partner in the Ainsley case. That's exactly what it says at page 10. Let me go one step further, though, Your Honor, to come back to the point on treating it as without cause. The issue with that is that is what allowed Mr. Hsu to keep his units under the plan. But that is not the mechanism for what is at issue here, which is the process by which Castleton was going to call or to buy back those units. That was a separate agreement that the parties worked out at the time of the termination. And that's a crucial part because what happened here, what allowed the termination without cause allowed him to keep the units, but it did not require the company to buy the units back. In fact, there is no obligation for the company to buy the units back. That was a separate negotiation in the termination agreement at the time of the termination.
Let's assume you're correct, that forfeiture for competition in Delaware, we would agree with you, would be viewed as a contractual obligation. Tie that into New York public policy. Is it violative of New York public policy?
Absolutely not, Your Honor. It is not repugnant or, I mean, this court knows what the standard is, all right? It does not come near that.
Why?
I can explain to you. Okay, a couple of reasons. First of all, the Brown case that Mr. Littman relies on, okay, is not analogous to Delaware or New York at all. In fact, the Brown case requires an employer to make a prima facie showing that a restraint is necessary, and then the burden shifts entirely to the employee. And what the court in Brown said is that Florida focuses solely on the employer's interest. That's the quote. That's the reason they said it was not appropriate. Additionally, all right, well, that is nowhere near the case here. Additionally, the employee in Brown was in New York. The employer was in New York. Here, there's no nexus. There's
also, wasn't Brown a restrictive covenant?
Yeah. Yes, that's true. That too, Your Honor. That too, Your Honor. And here, right, so there's no nexus here. Castleton is not based here in New York.
Where does duration come into this? The fact that it's just 18 months.
Oh, well, Delaware courts have found covenants for 2 years or more.
Well, New York courts. I think we're looking at New York law.
Oh, okay, okay.
Analyzing it, whether it violates our public policy.
New York courts also have done that, but again, that is in the forward look. And here, we're looking at it the other way because we already know what he did. And what did he do? He competed within 4 months. 4 months later, he's the president and the chief executive officer of a newly formed subsidiary of a multi-billion-dollar company for which he's getting paid $500,000 a year. He's got the company apartment, the company car, a physical office, staff, equipment, you name it, he has it, and he's trading the exact same commodities in the exact same area. So they've never said, and they've never cited any New York case or Delaware case or case anywhere that said that if someone competes within 4 months and trades the exact same thing in the exact same area, that would be an issue with any factor of the reasonable test, if the reasonable test should apply in the first place. I see my time is up, unless Your Honors have anything further.
Thank you, counsel.
Thank you very much.
2 minutes, counsel.
I think counsel just misspoke when he said that my client traded commodities, which he did not do. There's no evidence in the record. He prepared to compete, but he never competed.
So is it your view that preparing to compete is not a breach?
If a non-compete covenant, either in a forfeiture for competition provision or even in a prohibitory non-compete provision, said that the employee could not even prepare to compete, it would be unenforceable because employees could, by interviewing while they're employed or preparing to compete. The law in New York is very clear that you can take measures such as even signing a lease, getting business cards, and all that kind of preparatory activity is not something that a non-compete can prohibit. There's absolutely no evidence that my client ever did any commodities trading. The business never even got off the ground. With regard to the idea that the benefits, the post-employment benefits that my client supposedly forfeited are somehow circumscribed by the fact that they weren't salary and the like is
But what about that? Isn't that a fair point? That these were voluntary benefits. You didn't have to take them. You could just live with the contract.
That is true, but you could say that about any of the benefits in any of the cases following Post v. Merrill Lynch. The employee didn't have to want his deferred compensation. In Morris v. Schroeder.
This is essentially a gift. Isn't this essentially a gift?
No, it's earned compensation.
It's an equity program, right?
It's an equity program that is tantamount to being a bonus. As you're working, you get the equity units as a reward for your work as well as to keep you retained. That's actually in the equity agreement itself. It's for employee retention. For the employer to throw the employee out and then claim that benefits that were given to him in order to retain him can somehow be forfeited is just wrong. Severance payments also are under the Scott v. Beth Israel medical case decided by the First Department in 2007. Stock options in Lennell v. Smith. All these cases involve post-employment benefits. Post v. Merrill Lynch, the 1979 Court of Appeals decision, which I think is right on point here for New York public policy, has never, ever been distinguished because of the kind of benefits that are bestowed upon the employee. There's no case, and there have been plenty of cases following it, no case distinguishes among the different kinds of post-employment benefits. Let me address one other point. I see that my red light is on, but the idea that Florida law in Brown and Brown is somehow different from a hypothetical Delaware Supreme Court decision that would deny my client his post-employment benefits here is fictional. The analogy is exact between Florida law, even though it did involve a restrictive covenant. Here, the New York Court of Appeals has held that a forfeiture for competition situation, such as my client found himself in, is tantamount to a restrictive covenant. That's what Post v. Merrill Lynch is all about, and that's what Morris v. Schroeder, another Court of Appeals case that followed Post, is also all about.
Thank you, counsel. Thank you both.
Thank you.
Consorca.
Good afternoon. Matthew Capizzoli for Appellant. It's a very simple appeal. From my perspective, the only issue is whether or not the sworn testimony presented to the lower court by the appellant was so implausible, so lacking in credibility, that it could be totally disregarded. I submit that not only was it plausible, but it was credible. This was not a sham affidavit that presented some sort of outlandish or unbelievable scenario. It was not an affidavit that was contrived to contradict prior testimony. It's a simple, straightforward matter. Mr. Mouchouar submitted a sworn affidavit that said that his company, Consortia's management acknowledged that Consortia owed Nakahama $2 million. He returned $1 million of that money to Nakahama and retained $1 million.
Oh, this is subject of other litigation, right?
It was.
What happened?
I wasn't counsel in those cases, but it was subject to other litigation, yes.
And that litigation is over?
That litigation ended because Mr. Mouchouar was unable to pay his attorneys and was defaulted. So getting back to the affidavit, $1 million was retained, which was the exact amount of money that Nakahama owed to Mr. Toller's entities. And then when the relationship soured, in part because of the litigation you just mentioned, Consortia declared a default and then filed this 3213 action. The lower court stated without any real explanation, at least in my opinion, that the statements were self-serving and speculative. I don't think they're either. I think on their face, Mr. Mouchouar made clear that Mr. Toller represented they would withhold the $1 million, which would be used to pay off or pay down Nakahama's debts.
Oh, that's a different entity, right?
Which?
With a different Nakamura, the other litigation.
No, Nakahama was the party to the note in this case, the note that Mr. Mouchouar guaranteed.
In the prior litigation, who owed the money?
In the prior litigation, there were a number of different entities involved. I know. The prior litigation, I believe it was Nakahama was the debtor again, but the borrower was different. I'm sorry, yeah, the lender was different. I think the lender was, trying to remember the name of it.
Another related entity.
Well, it was related. It was an affiliate of Consortia. Same management, same concept. And, these are two business people with a lot of different entities who are dealing one-on-one various different ways. As I set forth in some of the cases in my papers, there are plenty of examples. I don't discount that the lower court has discretion to determine in some situations that testimony should be totally disregarded, but I don't see a basis for it here. The idea that you can come forward in court, present an unwaivable defense like payment, and just be said without any really supporting reasoning that that's self-serving. Not every, self-serving could mean a lot of different things, but in this context, it means there's something extremely uncredible or suspicious about the representations in the affidavit, and that we don't have that here.
Right, it would really have to be incredible as a matter of law because most parties' testimonies, not surprisingly, are quote-unquote self-serving.
Of course, yes. And here, as you well know, it's not for the lower court to determine credibility. That's something that we've relied on discovery. And just one other point, the fact that Consortia had a contractual obligation to provide audit and information about what happened to the money, and they've refused to do that, I think also supports the credibility of Mr. Mouchouar's testimony. Thank you.
Good afternoon, Your Honors. Evgenia Vetrenko for Respondent, Consortia Management, LLC. My opponent noted that it's the question of plausibility of Mr. Mouchouar's affidavit that's at issue, and I respectfully disagree. The issue is not whether the affidavit is plausible. The issue is whether it raises an issue of fact. And for it to do that, the affidavit has to be supported by objective evidence. It cannot be an affidavit that just says, well, the lender actually repaid the loan. And in fact, Mr. Mouchouar's affidavit doesn't even say that. It relies on a hearsay representation by Consortia's principle that Consortia may apply certain of the funds that Nakahama may earn under a separate agreement towards the loan. And in the same affidavit, in the same paragraph, Mr. Mouchouar actually said that that promise was never borne out, meaning that the promise to apply some of the payments towards the loan
never actually happened. So there is no issue of fact as to whether the loan was ever repaid. And the lower court properly made the determination. The second point.
Were you in possession of the information about Nahak Khan's accounts?
Yes, so that's the second point, and that's...
Couldn't you have submitted that information to refute the defense?
It was not submitted in this case because the cooperation agreement and the parties' obligations under that agreement are not part of this case. It's not part of the promissory note and the loan between the two parties. It's a completely separate agreement, and there was a completely separate litigation as to that agreement.
But wouldn't it have refuted the defense here?
It may have refuted the defense here, but the point is that the guarantee was absolute. It was unconditional. So the defense that goes to the lender, Mr. Mushawar, does not have access to that defense. Like New York law has recognized that absolute guarantees do not allow the guarantor to raise defenses, offsets, or any or counterclaims.
So it's your view that any monies owed under the cooperation agreement is other litigation, and that has to be resolved in that litigation, or what?
Yes, correct. Any question whether there is any amount owed or there isn't is part of that litigation, and it's not on the record, but there is...
It's not on the record, we
yes.
don't want to hear it.
Yes, I'm not going to go into that, yeah. If your honors don't have any questions, rest.
Very quickly.
So what about that? What about that last point? Your adversary says, you know, different agreement, different parties. If monies are owed there, then that's something that has to be enforced over there.
I would say that defensive payment is completely appropriate in a 3213 context. Imagine if Mr. Mushawar had paid in gold or by transferring valuable property. And there's an acknowledgement of payment. There's not an obligation there to bring a new claim for breach of contract. The facts here support, at least at this stage, that the payment was made and it was acknowledged. There's no other cause of action to bring at this point other than the defense of payment. You know, asserting that the payment was made, it was accepted, and this debt is extinguished. Just a couple other things. The statements are not hearsay, in part because the statements are the issue in the case themselves. It's almost like an oral contract. When you have an oral contract, testimony about the terms of the contract isn't hearsay. It also falls under the exception for an admission by a party opponent. And finally, with respect to the language about never borne out, that language simply refers to the fact that after the deal was made, after the acknowledgement of payment was made, Consortia sent a default notice and filed this lawsuit. So when he says the promises were never borne out, they were never borne out because Consortia retained the $1 million and then sued again. And finally, I don't want to go out too far on a limb, but I think there's a little bit of a Riggs v. Palmer type of element to this case where courts should not be used as an instrumentality of a wrong. And there's a great deal of injustice associated with accepting a $1 million payment and then being able to sue and not affording the debtor, in this case Mr. Mushawar, his opportunity to be heard in court. Thank you.
Thank you, counsel. Thank you both. Brannick International. You may proceed, counsel.
Thank you. Thank you, Your Honor, and may it please the court, David Haberman of Rose & Rose for the appellant. Your Honors, we would respectfully submit that the lower court had erred in applying a 10-year lien duration that applies to a relocation lien to monies deposited with the county clerk, which specifically discharged the lien. And this isn't a case where there is...
But let me just stop you there for a second. Wouldn't the legal effect be that the lien is discharged on the real property, but the lien still continues on the monies being held by the court?
Well, it's not that the lien continues, it's a lien on monies. It's a different lien at that point in time. It's not the same lien, and the...
But why does the lien, why does the nature of the lien change? Because the reason why it's been removed from the property is so there can be a sale of the property, and then the proceeds are put into court, so the parties can litigate that issue, no?
Well, the administrative code has specific exceptions, and it says the mechanics lien law governs with the certain exceptions. One of those exceptions is the 10-year lien, and within that 10-year lien, if a party takes action to discharge the lien, and that's what happened here, the 10-year duration no longer applies. And this is not a case.
Because under Administrative Code 26-305, 4, you are pointing to the fact that it says, but the effective enforcement of such lien or lien governed by the provisions of law regulating mechanics liens. And that's what you're pointing to. I didn't read the whole thing, but I'm sure you're familiar with it.
Yes, Your Honor.
Which has the 1-year proviso. But then that sentence continues, and by the provisions of paragraph B of this subdivision, and it takes you right back into the next provision of the administrative code, which says 10 years.
Well, but it's silent on the issue of discharge. And once you get to the issue of discharge, and there's a lien on the monies, which is a completely different lien, it's a different
But is it
process.
silent on discharge? Because the provision continues to say, or in the meantime, taken to enforce or discharge such lien. So the provision seems to be contemplating what you're talking about, and it seems to be saying 10 years. No?
Well, except if something is done where the lien is discharged, and that's exactly what happened here. Now you have cash on hand in the county clerk's office. It's a different lien. It's money that's available. It's no longer a lien on property. And the administrative code specifically says that a relocation lien is a lien on the building and the property on which it stands. This lien is discharged. That's very clear in the law. And it becomes a lien on the money. And once it's a lien on the money, mechanics lien law applies, and it's a 1-year duration.
What do you do with subdivision B of the administrative code?
I don't think
of 26-305.
I don't think that subdivision B, I mean, that is the issue at hand, and it provides that if there's a judgment, and there was no judgment here, that the same lien continues for the same duration. We have a change. That lien has now become a lien on money. Again, there's cash on hand. The city doesn't have to foreclose on the lien, sell the building in a foreclosure sale, and possibly there not even being the money to satisfy the lien.
As a practical matter, what needs to happen here is someone's got to go down to the city and say, look, you've got the money here, let's get this paid off, so that you stop the running of interest. And that's what needed to happen.
Well, it would have been nice if that happened in 1998, Your Honor. What we see is a lien went from 213,000 to 900.
And that's what this regulatory and statutory scheme seem to contemplate.
Your Honor, we have a lien here that was extended ex parte twice for 10-year periods. And that's why you had a situation where it ballooned to over $900,000. When my client monetized it, it then became the 1-year lien. And, then it was up to the city to try to collect the money. But
Thank you, Counsel.
thank you, Your Honor.
You may proceed, Counsel.
Good afternoon, Your Honors. May it please the Court, Jennifer Lerner on behalf of Respondent. The Court should affirm here, this is a 10-year lien. The deposit of monies with the Court does not change the duration or the nature of the lien, and there's nothing either in the lien law or in the administrative code provision suggesting that a deposit with the Court changes the duration of the lien. There are myriad cases that are even cited by appellant. Harlem Plumbing Supply, 40 AD 2nd, 768, a First Department case from 1972, which explain that depositing money with the court simply transfers the lien from the property to the deposited monies. So there is nothing.
Oh, you're saying the nature of the lien doesn't change? I mean, that's what your adversary is arguing. Now it's a lien on money, mechanics.
Yes, and I completely disagree. There's no basis. I mean, I know, you can call it a lien on deposited monies. It is, but it's still a relocation lien. It's just on the monies instead of the property. And the city still has the remainder of that 10-year period to foreclose on the lien. This idea that because you deposited monies, somehow it magically changes to 1 year because that's the default duration for a mechanics lien, which provisions can be used to govern the enforcement of the lien. There's no basis for that change. When you look at the provisions of lien law 17 governing duration, they don't apply here because we have a different duration. The lien law 20 applies, which is the provision for deposit of funds, but there's nothing in there that changes the duration of the lien. I also just note that, as the court noted below, if you could change a lien simply by depositing monies, you would need to notify the city. Here, the city has the 10 years. There's no reason for them. I mean, they could go to foreclose on the lien, and likewise, Brannick could provide notice under lien law 19, requiring them to commence an action to foreclose. But you can't just kind of go deposit monies and say, haha, gotcha, we've changed the duration of the lien here without you knowing. It's still 10 years. That hasn't changed.
Thank you, Counsel.
We respectfully ask you to affirm.
1 minute, Counsel.
Thank you, Your Honor. It's not an issue of a loophole. It's not an issue of magic or a gotcha moment. It's an issue of where the legislature specifically wanted to address the lien on discharged monies. They did in lien law 17, where it says the provisions of this section in regard to continuing liens apply to liens discharged by deposit, and that's under the mechanics lien, that's section 17. Under the administrative code, they did not specifically address it, so it does get kicked back to lien law 17, the mechanics lien provisions. And there was notice, Your Honors, and you may have seen there was prior litigation between the parties on a different issue, and during that litigation, the monies were deposited to discharge the lien. That became part of our reply brief in the other litigation and was made a part of the record on an appeal in that litigation and is part of the record on appeal in this litigation. So even though there's no obligation for the appellant to have notified the city was on notice. Thank you, Your Honor.
Thank you.
Have a good evening.
Get home safe, folks.
Thank you. You too.